Good morning, good morning, good morning. First of all, let me apologize for my tardiness. Uh, Natalie won't be joining us today, everyone. I apologize for that as well. Um, she had an issue. She's got to leave. A friend of hers had a death in the family. So we are, she's dealing with that. And that kind of put me behind a little bit. Tread, good to see you here. Jeff, Celine, good to see everybody. I believe Miss Carol says she's going to try to join us a little later, that she's got something to do first thing this morning, but she's going to try to join us in a bit. The trial has started, so we're going to get to that. But in my tardiness, I was kind of listening in, and there's little motion practice that we're going to be privy to this morning before we hear from any witnesses. So, I have been able to pull up some information regarding this motion practice, because this defense attorney is on a roll here, and he's got some interesting reading for us to do this morning. But since we're a little late, I'm just going to jump right into it, and we're going to get started here. Thank you all for joining me. Let's see what they have to say. Oh, we're just going to look at the ceiling for a while, apparently.
Ms. Shaver, please state your full legal name and raise your right hand.
Laurie Filmer, previously known as Laurie Shaver.
You solemnly swear or...
All right, so she's not about to take the stand. The reason that she is being sworn in now is because she's going to be speaking during this motion practice, and the judge wants to make sure that everything she says she is not lying about. So we will see how accurate her statements are.
Affirm that any testimony you give today shall be the truth, whole truth, nothing but the truth, so help you God. Thank you. All right, are there any preliminary matters before we call the jurors in?
Yes, Judge.
Okay.
Judge, you may recall back when the state had filed their motion to allow the deceased father, Mr. Shaver's father, attend the trial, sit through the trial. We had invoked the rule of sequestration at that stage. We'd asked the state to advise, the court directed that they advise Mr. Shaver that he was not to be making any statements. So at that stage, the rule had been invoked. Yesterday, throughout the trial, the state has had present.
All right, so the rule of sequestration is that while a trial is going on, or even in depositions, because depositions are supposed to proceed like trial. So if I'm taking a deposition, I can invoke the rule of sequestration during the deposition. And what that means is everybody who is not a party to the action, or if there's a corporate defendant or a corporate plaintiff, that corporate party's designated representative, everybody except them, who are going to be witnesses, who are at some point going to testify, have to leave so that they can't hear other witnesses' testimony. The exception to the rule, I believe, is spouses. I believe spouses can remain in some circumstances, but other than that, only the parties to the action can hear what everybody is saying during the course of a trial or a deposition.
Good many of their witnesses here observing the openings and the testimony of the foremost witness at that date. So we ask that these witnesses that have been present, that they be excluded, barred from testimony, and that the state thereupon now advise the remaining witnesses not to not that they would advise them about the rule of sequestration
I
having
don't
been
recall you
invoked.
invoking the rule.
Pardon me?
I don't recall you invoking the rule.
Yes, I did. I did right at that stage. I said, Judge, we're invoking the rule of sequestration. We'd ask the court and we'd ask the state to instruct the father that the rule's invoked and he's not to speak to anybody at that stage, and for purposes at this time, the rule of
Motion, you
sequestration.
invoke the rule, or you invoke the rule in court?
I invoked it here before the court.
All right.
Mr. Wicks invoked the rule during the perpetuation of the testimony of Jessica Holcomb because we had technically started the trial at that stage. When we put her on, he said that he wanted to invoke the rule then. And the rule has been invoked. I've informed all the witnesses that they are not to discuss anything that has gone on in this case. And the only listed witness that is testifying that has been present is Douglas Shaver, the witness that you said was allowed to be here.
There were witnesses on newsreels last night.
All right, so in case you are having trouble following along, defense invoked the rule of sequestration. They're now saying there were all these witnesses who were in the courtroom yesterday for opening statements and for that first witness. Essentially, the defense attorney is trying to make his first basis for a potential appeal. If witnesses who were present for prior testimony are then allowed to testify, then their testimony could be influenced. So if those witnesses who were allegedly in the courtroom are allowed to testify later, then he can say, I need an appeal. I'm appealing the verdict against my client because these witnesses, their testimony was influenced by prior witness testimony.
Watching the news, the rule had been invoked. Witnesses were present in the courtroom yesterday, and that was specifically regarding Mr. Shaver. We weren't talking to Ms. Holcomb. Ms. Holcomb was released from her state.
What other witnesses specifically were present that you're concerned about?
Ms. Shaver, yes.
Okay.
Who was present?
Sharon Shaver. It was noted in the opening statement that Sharon Shaver would be testifying, Brian Shaver, Stacy Shaver, and I did see Tamara Dale here yesterday along with many CSI agents. And I cannot identify the CSI agents because I was not there on scene. So how would I be able to distinguish who is going to be testifying and who was sitting in the courtroom yesterday?
Your Honor, Tamara Dale was not here. Sharon Shaver is the decedent's mother. I listed her as someone that you might hear referenced, but she is not testifying. She was listed as a B witness. The CSI individuals that are here are all CSI individuals that were not even working with the sheriff's office at the time of the discovery of Michael Shaver's body in the backyard. None of them are listed witnesses. They are CSI agents that are allowed to be here to observe court process as a learning tool, and there's nothing to prevent people that aren't witnesses and that weren't even with the sheriff's office at the time of this investigation of being present.
Well, it sounds like the individuals that were present are not being called to testify. Is that correct, Mr. Camuccio?
Yes, sir.
Okay.
Who was it the state's acknowledging was present?
Douglas Shaver.
Nobody else.
No witness that's being called has been in this courtroom in violation of the rule.
Okay, and nobody's watched the news?
I can't control that.
Well,
So do you see how the defense attorney is now trying to turn it from, okay, even if they weren't there, did they watch the news? So the rule of sequestration does not apply to watching the news. Of course, the witnesses are given instructions not to watch the news, but there's just like the jurors are given instructions not to watch the news, there's nobody monitoring that. So to now try to require the prosecutor to ensure that no one is violating any of these rules outside of the rule of sequestration is a bit much.
I've told the witnesses that they can't discuss the matters that happen in court.
So they're not to be present in court. They're not to discuss any testimony or with any other witness.
We have screenshots, Judge, of people that
So-
listed witnesses on.
Yeah, and these aren't really good. I guess my concern was during opening statements, Mr. Baskley stated that we would hear from the mother, the father. The father, we had the motion hearing on. The mother, the brother, the sister, and they were all sitting in the courtroom yesterday.
The brother and the sister were not in the courtroom. They were sitting outside the courtroom the entire time.
She's got screenshots. Now, we saw the back of her head a lot of the time that everything was going on yesterday. And at no point did she turn around and take screenshots of the audience members. So her screenshots are probably out in the hall, and she probably screenshotted these people either talking to the press or sitting out in the hall or standing out in the hall at some point after everything that we saw yesterday happened. So this client has convinced her attorney to raise this motion right now based on her statement that these people were in the courtroom. And we're going to see that her statement was inaccurate at best.
So,
Judge, I would just, in an abundance of caution, I would suggest when the witnesses approach that the court make an inquiry whether or not they've spoken to anybody or watched anything on TV to assure that there was no violation of the rule. And for any lack of confusion at this state, again, we'd invoke the rule of sequestration, ask the state to advise the
Up to the
witnesses.
court to inquire of every.
So he just asked the court to ask all the witnesses, one, have you violated the rule of sequestration? And two, have you talked to any other witness or watched anything about the trial? So he's trying to get on the record bases for appeal, for possible appeal. This doesn't happen in any other case, right? So any cases that you've watched, you don't see the witness take the stand and the judge begin the questioning of the witness by asking, have you talked to any other witness about this case? Or have you watched anything on the news about this case? It doesn't happen. We just trust that people are going to follow the rules. And that's the way it's supposed to be, because otherwise we'd find out that nobody really follows the rules, in which case none of the court cases would work. We wouldn't have a justice system, essentially.
Witness or
Each witness that takes a stand, whether or not they've spoken to anybody, whether they were in the courtroom yesterday. And if they weren't, and they were listed, they should be
Sir, you're
barred.
making the allegation that there were individuals in the courtroom that should not have been in the courtroom. You tell me who you're concerned about, Mr. Wiggs.
Well, Miss, my client just advised the court, the mother and Tamara Dale, we suggest, was present, and
Brian Shaver.
Brian Shaver.
Stacy Shaver was here.
Okay, so Brian Shaver, Stacy Shaver, and Sharon Shaver. Who else?
Tamara Dale.
Okay, those four individuals.
Pardon me?
The court will inquire of those four individuals then.
You want me to bring this Brian Shaver and Stacy Turner in right now, Judge?
Are the other individuals present as Tamara Dale's here?
She's not here. She hasn't been here at all this week because she's not testifying until later. And as I said, Sharon Shaver is not testifying.
All right, well, let's bring them in and the court can make the appropriate inquiry.
The judge kind of split the baby. He said, okay, we'll inquire about those witnesses that you are specifically concerned about. But we're not going to trace every witness up here and find out if they violated any of these rules.
This shouldn't take very long. Okay, please state your name for the record.
Stacy Turner.
Okay, and spell your full name.
STACIE-TURNER.
All right. And were you instructed not to discuss your testimony with anyone?
Yes.
Okay. And have you discussed your testimony with anyone?
No.
Were you in the courtroom yesterday?
No, I was not.
Okay. And have you viewed or been influenced by any media reports, newspaper, TV, otherwise?
No, the very end of a story was on this morning, but I did not see it. I just heard Laurie's name mentioned.
Yes, ma'am. All right. State, do you wish to inquire? Okay. Mr. Wiggs?
No, I don't have any questions.
Okay. Are you satisfied with the responses, sir? Okay. And again, please continue. The rule is invoked. It remains invoked. Do not discuss your testimony with anyone. Do not view any media concerning the case. Do not do any research concerning the case.
Yes, sir.
All right. And please remain outside the courtroom.
All right, thank you, Your
Okay.
Honor.
Anything further? Okay. All right. Thank you, ma'am.
Thank you.
Yes, ma'am. Is there anyone else present that is of concern?
I can double check to see if Brian.
If you would, sir. We'll inquire
Brian's
as to
not
the
there.
other three named individuals as they arrived, and they are Sharon Shaver, Brian Shaver, and Tamara Dale.
Very well.
Sharon Shaver is not testifying.
Okay.
Okay,
Then she's not of concern, so just Brian Shaver and Tamara Dale.
very well.
All right.
Judge, I have one other matter.
Yes, sir.
Okay, because we've been drawn up to the bench a few times, and
Is it the standing objection that you'd like to make?
well, yeah, I want to make it very clear for the record, see where we're going to proceed on this, but I want to make it very clear. And I'm going to hand the court the prior decisions, which the state has copies of. Okay.
Yes, sir. Thank you.
Yes, sir. You see some cover notes on the first page, and that's just an outline of the Speth versus Carlisle decision and the Volker decision. Both cases are attached. We got drawn into this because there were early.
All right. So before he tells you what the Carlisle decision is about, what he's about to argue is based on stacking inferences. So here in Florida and throughout the country, pretty much, there used to be this criminal rule that you can't stack inferences in criminal cases. So you can't take this circumstantial evidence and ask the jury to infer from the circumstantial evidence a certain fact. And then once they infer that fact, then put some more circumstantial evidence together with that fact and have them infer something else, because now you've stacked an inference on top of an inference. So the leading case on this was the case of Volker versus Combined Insurance Company here in Florida anyway. And here's what Volker had to say about it. And this is a 1954 case. We think, however, that such method of establishing an ultimate fact should not ordinarily be indulged unless the first inference meets a test which may be analogized to the criminal rule concerning circumstantial evidence, i.e., in the ordinary case, only if the prior or basic inference is established to the exclusion of any other reasonable theory should another be drawn from it. So this is a civil case here, and they're saying we should base our civil rule on this criminal rule that says in order to get the first inference or the second inference to stack on the first inference has to be one that the jury draws to the exclusion of all other possible inferences that could be drawn from it. So understand, we have a civil rule that's based on a criminal rule, and this is a court in a civil matter establishing that rule here in Florida. So then we go to Bush v. State. Now, this is a Florida case from 2020. This is a criminal case. Now, remember the rule applied in criminal cases, and then we transferred it to civil cases. So in this case, the court says, look, the Supreme Court of the United States said that this rule is stupid. Here we go. In summary, there was a time when all federal courts and almost all state courts instructed juries using a special standard when the evidence of a defendant's guilt presented at trial was circumstantial. In 1954, however, the U.S. Supreme Court called the standard into question, opining that where the jury is properly instructed on the standards for reasonable doubt, such an additional instruction on circumstantial evidence is confusing and incorrect. So we're going to explain what all that means, but that's the basic proposition. In the wake of Holland, that's the U.S. Supreme Court case, all federal courts and most state courts ceased use of the special circumstantial evidence instruction and its corresponding standard of review on appeal. So they had this special instruction on circumstantial evidence that they would read to the jury. Then, if the case was appealed, they had an appellate standard of review regarding the circumstantial evidence that kind of mirrored the special instruction. So it made sense to have both of those in place at the same time. Florida, however, when they got rid of the special standard that was read to the jury, did something a little quirky. Florida became an extreme outlier with a somewhat discordant position that the special standard should not be used to instruct the jury, but should be used by the appellate court to judge the jury's verdict. This court is saying the special standard. Okay, so now we're going to find out what that special standard was. The special standard is most often articulated by Florida's appellate courts this way, where the only proof of guilt is circumstantial. No matter how strongly the evidence may suggest guilt, a conviction cannot be sustained unless the evidence is inconsistent with any reasonable hypothesis of innocence. So if there is a reasonable hypothesis that can be made that this person is innocent, then, and the guilty verdict was based on circumstantial evidence, we have to overturn the verdict, even though the jury wasn't instructed on this. So they go on to say, however, it should be obvious that it wholly defies reason to suggest that a standard for determining whether the evidence is sufficient for conviction is incorrect if used by the juror. So the instructions being given to the jurors say one thing. It's inconsistent, and it defies reason to suggest that if it's okay for the jury for them to use this standard, then it's not okay for the appellate court to use the same standard. So it shouldn't be appropriate. It shouldn't be sufficient for the jury for this standard, and then appropriate for the judge who is reviewing the jury's decision to use a totally different standard to see if the verdict complies with the law. So in the end, they essentially say, look, we're doing away with this entire standard with respect to criminal law, and we are just going to go with the jury's instruction that is given to the jury. We're going to come in line with federal courts. We're going to come in line with most of the other state courts. And we're going to say, look, the standards that are read to the jury, the rules that are read to the jury, those are the similar rules that we are going to apply in an appellate standard, in an appellate context, to see if the jury rightly decided the case. So then comes in Smith v. Carlisle. Just the title alone, we know that this is not a criminal case. This is a civil case. So we are going to be analyzing the stacking of inferences, in this case, in the context of civil trials, not criminal ones. And in criminal trials, the Supreme Court in Bush v. State said, we're doing away with this criminal thing. They didn't apply that to civil cases. So Smith v. Carlisle starts out by saying, in Volcker, that's the first decision that we read. In Volcker, the Supreme Court explained that. And then they quote from the Supreme Court, stacking one inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged unless the first inference meets a test which may be analogized to the criminal rule concerning circumstantial evidence only if the prior or basic inference is established to the exclusion of any other reasonable theory. That's the same thing we read in Volcker, and I'm reading it twice for a reason, because he's about to say the same thing, but he's about to tell you, or try to tell the court, that the first DCA, the appellate court that is deciding this case, Smith v. Carlisle, actually said that, and that they said it in 2024, this year. He's about to tell the court, this is what the first district said. Not this is what the first district was quoting Volcker having said in 1954. And then he's going to basically say, so this means because the first DCA is applying it here, this means that in a criminal context, Volcker is still good law. Either the defense attorney can't read, doesn't have reading comprehension skills, or he's trying to pull a fast one on the court. Those are the only two explanations I can come up with for this. Because at the very end of this, they say it would defy they basically say, look, we didn't rely on stacking inferences, so it doesn't matter. But let's go through this because we think that the Supreme Court should undo this this stacking inferences issue with respect to civil cases. Here's why. It would defy reason to hold that a person can be sentenced to the ultimate penalty under the law, death, based solely on circumstantial evidence that does not exclude every reasonable hypothesis of innocence, but a plaintiff can't survive a motion for summary judgment in a civil case based on circumstantial evidence and all rational inferences arising from that evidence, unless the initial inference excluded any other reasonable theory propounded by the opposing party. So basically they're saying, look, if a criminal defendant can be sentenced to death based on circumstantial evidence and they don't have to exclude any other reasonable theory, then why in a civil case where we're not dealing with someone's life or liberty, can we not have a similar rule? It doesn't make any sense. And then they call upon the Supreme Court to go back and review this in a civil case based on their decision in Bush, the second case that we read. Therefore, it seems both logical and likely that if and when the Supreme Court is presented with the question of the continued viability of this proposition of Volcker in light of Bush, which has eliminated the criminal rule on which that proposition relied, that court will harmonize the two decisions and discard this proposition in Volcker, as it now imposes a heavier legal burden on a civil plaintiff than the state must meet in a criminal case, even a capital case, where the state must prove guilt beyond and to the exclusion of every reasonable doubt. So that's what we have. We have this. I'm sorry. That's what we have. We have this this defense attorney essentially trying to apply a civil rule in a criminal case, even though he actually names the criminal case that overturned the rule, but then quotes from a later civil case that still applies the rule in the context of civil and says, this is the rule that you have to follow, judge. So let's see how the judge and the defense team deal with this.
There was earlier talk about the concept of inference stacking. Mr. Camuccio and I addressed the matter, and there was some argument that took place about it. I went back and I knew the rule had been changed, but I wanted to see how it was changed, and I came upon the Smith versus Carlisle decision, and that decision is cited at 378 Southern 3rd, 1213. It's a 2024 decision. It looks like out of the first DCA. What the case did was it broke all the history down, and going back to Knight and Sims and Law, and going back to the Bush decision, which had revoked the concept of inference stacking. What it said was, yeah, the inference stacking doctrine is gone. And it went back and it said, what thus is imposed is the decision of Volcker versus Combined Insurance. And that site is 73 Southern 2nd, 403, Supreme Court decision back from 1954. And in it makes this statement, stacking.
So understand what he's saying. He's saying, look, this decision said the stacking inferences rule is dissolved. This 2024 case, Smith versus Carlisle, recognizes that the stacking inference rule is dissolved, and so what we're left with is Volcker. That's not what happened. The stacking inference rule was dissolved in criminal cases, and we've always had Volcker with respect to civil cases, at least since 1954 when it was decided. The rule has not changed at all. This case is merely recognizing that it should be changed based on the change in criminal law.
One inference upon another as a method of establishing an ultimate fact ordinarily should not be indulged in unless the first inference meets a test which may be analogized to the criminal rule concerning circumstantial evidence, only if the prior or basic inference is established to the exclusion of any other reasonable theory.
He just said that that's what the first district said. One, no, they didn't. They were quoting Volcker. And two, even if they were, that is in a civil case. You're here defending a criminal defendant. You should probably rely on criminal rules.
Now, when I'm drawn up to the court, I've advised the court and I've advised the state, what's the primary inference that you're trying to stack this inference on top of? And Mr. Camuccio's argument has repeatedly been, make your motion for a JOA at the end of the trial. Well, to follow Mr. Camuccio's logic would do away with 90.401 relevance, and it would do away with 90.403 whether there's any prejudice by the inference to be drawn. So everything that Mr. Camuccio would propose through any proposed circumstantial evidence would be relevant in the mind of the state, and the defense would be required just at the conclusion of the case to move for a judgment of acquittal. So I think that the state would need to verify the inference that they're building, their primary inference that they're offering any substantive evidence. That's what the case would suggest. Further, Judge, I provided the court the motion to exclude digital data which had been filed in this case and to strike the business record certifications. In it, and this, we got drawn into this at the bench the other day, the state had spoken about they were in possession of business records from Facebook and that they were verified and that they were to be offered, and that all these inferences could be drawn that this was Laurie Shaver. You may recall in our prior hearings, Mr. Camuccio was advised in the court, Mr. Wiggs can't just introduce a business record and assume he's just going to get the evidence and the documents into evidence. What I did for the state And the memorandum you'll see was I set forth all the known predicates for the introduction of digital data. It's not sufficient just for one party to object on predicate without offering and showing the opposing party what the predicate is. So in there, you'll see I'd cited Monceau, State versus Love, a number of cases as to how the predicate was established in other cases. I'd also
All right, so just so everybody understands what he's arguing here, he's saying, look, he's kind of mixing a bunch of stuff around. There's a business records exception to the hearsay rule. The hearsay rule says you can't take out of court statements and bring them into court and basically repeat them in court as if they were said in court, essentially because the other side doesn't have the ability to cross-examine whatever person made this alleged statement. There are exceptions. One of the exceptions is the business records exception. The business records exception says, look, if a business is engaging in business and they're making records in the normal and ordinary course of their business function. So this can't be any business document, something that is made outside of the normal course of what they do in that business. So you would think of like, for business records, you might think of like accounting documents. So every month they create these accounting documents. So whatever is said in those accounting documents are business records at that point, and they're created in the normal course of the business. Those are an exception to the hearsay rule. You can bring them in to essentially demonstrate what they say, and we trust them because why would a business create, going through its normal course of business, why would it create these records from a year ago expecting that they're going to be, displayed in court or brought into court a year later and have those records be false? Why would they have falsified those records from the past just for this case? They likely wouldn't have, so we trust the records. And he's now saying, well, the prosecution wants to introduce these Facebook business records, but they have to have a justification for introducing these Facebook business records. Well, the fact that they're business records doesn't matter. So all of that talk about business records doesn't matter. Essentially what he's trying to say is, look, they have to establish a basis for introducing these Facebook records. And I guess they haven't done so. In my head, I think they likely have, because the Facebook records likely show that Laurie Shaver, a certain network was used to post these Facebook, these changes to two different Facebook accounts, one being Laurie Shaver's and one being Michael Shaver's. And so if the same network was used and Michael Shaver was dead at the time, then it's likely somebody who is very close to Laurie Shaver, because they had to have access to her account and to his account, or at least be in the same room or same house when her account was accessed and when his account was accessed, or they wouldn't have the same IP address. So there's likely a reason to introduce these records. So I think this is another shot in the dark here. He's just throwing things at the court.
Also asserted cases that dealing with confirmation of the data and how matters had to be authenticated to show reliability, that you could not just introduce a business record and say the predicates met. The state went beyond that later, you may recall, and it filed a request for a summary to be introduced into evidence. I advised the court that what the state was doing was the state was going to try to stack inferences and conclusions within it that did not constitute a business record. And the case that I cited in the primary motion was Yisrael, Supreme Court decision. or an after arrest document generated in preparation of litigation was not.
Sorry, Tread just said I was muted. So a summary of a business record is not in itself a business record and is not admissible into evidence because it could have been changed after the business record was made. But typically what you'll find is the plaintiff and the defense, or prosecution and defense, will typically agree, if you have voluminous business records, that this summary is an accurate reflection of what is contained in these business records. And by their agreement, the court will then allow that summary to be introduced into evidence so that the jury doesn't have to waste time going through, hundreds of pages of business records just to find the few facts that are buried in there that are helpful to either side.
A business record and clearly outline that case and discuss it for the court openly. Now, none of this was contested in the hearing. Nothing was contested. We introduced it in the form, likewise, with digital data, testimony of Richard Connor, the predicate standards. The state just kind of covered their eyes on it, I think, thinking they're going to show up and just say, well, here's a business record and here's the inferences we conclude from it. Now, again, that brings us back to Carlisle and relationship with the digital data. So I supply that to the court instead of having to approach at all stages, advising the court that when we call them out or call the state out as to relevance, that's the authority that the defense has relied upon. That's the obligation for the court to inquire. When we talk about digital data in reference to that, those are the predicates that are set forth before the court and the state, and ask that the court hold the state to their predicate requirements as set forth by the court. So with those, Judge, we just preserve the record and ask that the court enforce the law and call the state out on these issues. Thank you, Judge.
Thank you. State's response.
So sometimes it's very difficult to establish the predicate necessary to get a business record in, especially when you're dealing with a large corporation like Facebook. Facebook is the one who kind of has to say, this is an accurate business record. And it's sometimes very difficult to get Facebook to say that, to get Google to say that, to get all of these large corporations to give you the tools and stuff that you need to be able to prosecute your case or to make your case if you are the defense. And that might be what he's saying, that they haven't gotten the requisite documents from Facebook certifying that whatever they have gleaned are accurate business records. But I would venture to guess that the prosecutor's office has the wherewithal to get the a company like Facebook to establish the business records, give them the information they need to be able to establish that this is a business record. Yeah. So I don't think he's being condescending to the judge. I think he's just, this is just his demeanor. Oftentimes we as attorneys are called upon to educate the judge, and we also have to establish the record. The judge knows we have to establish the record. And so he'll just let us, the judge will typically just let us talk so that we can establish our record, just in case we have to appeal anything that the judge does. Half the time the judge isn't even listening to what we're saying because he already knows it all. He's already dealt with these issues so many times in the past that he's just letting us get it out there for the sake of the record.
Your Honor, these issues have already been litigated. You've already made your ruling. I will point out, as I did up at the bench yesterday, that the defense, first of all, is relying on a civil case, Larry D. Smith versus Carlisle Industrial Break and Friction, is not a criminal case. The case that it refers to being Bolter v. Combined Insurance Company, once again, is not a criminal case. But the case that he cites clearly talks about how the Florida Supreme Court in Bush has done away with this standard that the state must do away with any reasonable hypothesis of innocence, and a conviction can stand based on circumstantial evidence alone. So their reliance on this civil case is misplaced. It's not saying what he says. The case that this court needs to rely on is the Supreme Court's decision in Bush. But all these other issues have been litigated. We have rulings, you've done orders, and simply rehashing all of this is inappropriate.
Judge, if I may, just respond
sir.
to that. Judge, you have not signed an order saying the state has a right to avoid any predicate obligation. But I just read to the court what the Smith decision said. And the Smith decision said a test which may be analogized to the criminal court. So while it was a civil case, they were relying on the standard to be imposed in a criminal case. So the state miscites one that the court has never entered an order saying you can avoid any predicate obligation, state. The obligations are still in place, and those obligations are set forth in the memorandum to exclude the digital data. They're also set forth in Smith versus Carlisle and Volcker. And that's plain, it's on paper, and the court could not, even if it wanted to, state, Mr. Camuccio, don't worry about 90.401, everything's relevant. Don't worry about 90.403. It doesn't matter if anything prejudices the defense. Everything's got to be analogized when it's tendered to the court.
All right, anything further? All right, thank you. Are we ready for the jury? All right, please call in the jurors. Thank you.
Let's fast forward it a little bit.
Make it clear on the record. She had mine.
Good morning. Please state and spell your name for the record.
Rita Merritt, RITAMERRITT.
Please raise your right hand. I'll swear you in. Do you solemnly
This is the
swear
wife
or
of the
affirm that any
witness from
testimony you
yesterday.
give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Good morning, Ms. Mary.
Good morning.
You're a little soft-spoken, and we're trying to make sure that that microphone picks up everything you say. So you can lean in and talk a little bit about it. Can you please introduce yourself to the jury?
I'm Rita Merritt.
Did you know Michael Shaver?
I did,
How did you know him?
through my husband, Frank Merritt.
And how long did you know him?
For about 6 months or so.
And were your families friendly? Did you socialize together?
Yes, sir, a couple times.
And did you ever go over to his house, to Michael Shaver's house, to visit or socialize with Michael Shaver, his wife, and their kids?
Yes, sir.
And did you socialize at other locations other than either of your homes?
Yes, sir.
Have you ever met Laurie Shaver?
Yes, sir.
And did you meet her through Michael and your husband?
Yes, sir.
Do you see her and recognize her in the court today?
Yes, sir.
Can you point her out and just describe something she's wearing?
The tan jacket.
Now, did you meet Michael or Laurie first?
Actually, I met them together.
And I want to take you back to November 7th of 2015. Did you see Michael and Laurie Shaver that day? Okay, you did.
Yes, sir.
Okay, sorry. And where did you see them?
At the Florida Flywheelers show.
What kind of event was that?
It was an event that had like old steam engines and tractors and kind of like a swap meet type of place.
Who all was there as far as your family and their family?
Mike and Lori, their 2 kids, Aiden and Isabel, my husband Frank, my daughter Carly, and myself.
And did you see Michael and Laurie Shaver interacting together?
Yes, sir, when we first got there.
And what was the demeanor of those individuals while you were there?
Objection. Just calling the witness to speculate on the mental process of another individual.
It's an individual's lay opinion of another individual's demeanor. So,
It'll cause their mental impression.
all right, overruled. You may answer.
Describe their
It seemed to be there was some tension between them.
Why would you say that?
Well, when we got there, we met up, and it was like, I don't know what happened. They just were their friendly selves.
Now, at some point, did Mike, Laurie, and their kids leave without you and your husband and your daughter?
Yes.
And just to be clear, you guys arrived separately in different vehicles.
Yes.
Now, on that day, was that the last time that you either spoke or saw Michael Shaver?
Yes.
When you were over at their house, did you ever observe anything that was being utilized as a fire pit?
No.
In the backyard, was there an area where the family had started some sort of construction of something that they wanted to put in there?
Mike had talked about digging a duck pond. They had ducks and chickens and stuff, and he had talked about digging a duck pond for his ducks.
And had that excavation, had that hole started to be dug while you were over there socializing?
The last time we were there was in September, the last time I was there, and I don't believe at that time that he had started it, but we did talk about it.
I have nothing further at this time, Judge.
All right, Mr. Wiggs.
Yes, ma'am, please score.
Yes, sir.
Now, ma'am, you testified that y'all socialized, correct?
Yes.
Okay. You never observed a murder, correct?
I'm sorry?
You never observed a homicide,
No, sir.
okay? Most you're saying is y'all went out to some truck show, I believe, and that somebody was in a bad mood?
Yes.
Okay. That would cause you to speculate about their mental thoughts, correct?
Objection, Your Honor.
No, sir.
No? Did somebody say I'm in a bad mood?
No, sir.
Okay. Did it occur to you somebody may have health issues?
Health issues? No, sir.
How was the temperature?
It was early in the morning, so it wasn't that warm then, but as the day went by, it got pretty heated, yes.
Very hot, did it not?
Yes. Mm-hmm.
So your conclusion, somebody was in a bad mood, doesn't take into consideration other factors such as correct? Health issues, temperature outside, correct?
Correct.
And they surely don't relate to any homicide that was committed, correct?
I would say no.
Thank you.
Any follow-up? May the witness be excused from her subpoena? Yes, sir. Okay. Thank you for appearing today. You're excused from further testimony. Have a good day.
Your Honor, can Mr. Wiggs and I approach real quick?
Yes, sir.
So is that what we're going to expect from every prosecution witness? He's going to get up and say, "Did you see the murder happen?" So you're just speculating. And this is an interesting defense. Very interesting. The jury knows that none of these people saw the decedent get murdered. Why is he asking these questions? And I can't imagine that the jury likes the way that he's talking to these witnesses. You can see when he kind of gets flustered with their answers, or when he gets kind of agitated. He steps away from the podium. He tries to approach them as if he's about to hammer something in. I don't know. I don't like it.
And I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Good morning. Can you please introduce yourself to the jury?
I'm John Borgwell.
And did you know Michael Shaver?
Yes, I did.
How did you know Michael Shaver?
So I was Michael's leader at Disney for a few years. He actually worked for me on 2 occasions. First time was when he was in his 4th year as apprenticeship in a monorail shop. So that was from roughly August of 13 through August of 14. And then in 2015, or in 2014, he transferred to Epcot when he completed his apprenticeship. I also transferred to Epcot in April of 2015, and that's where Mike worked for me again.
When you refer to yourself as his leader, is that basically a supervisor?
Yes, sir.
And in order to work as a mechanic at Disney, what did he have to do to get that position?
So Mike actually completed a 4-year apprenticeship as a mechanical apprentice in order to be able to work at Disney, and then also complete an exam in order to be able to work as a attractions mechanic in one of our attractions.
And how was he performing as an employee?
Mike actually performed really well. Was not happy on a personal aspect when he transferred to Epcot from the monorails, because I was at monorails, I wanted to keep him. But I was really happy when I transferred to Epcot and he was once again working for me.
And when, in the course of the time that you were supervising him, was there ever any discussions of his advancement within the program?
Yes.
Judge,
Objection,
hearsay.
sir.
Hearsay.
All right. Overruled.
So I was actually, in late 2015, I was actually ready to promote Mike to a working foreman position, which would have involved a pay raise, and that was primarily due to his work ethic and the way he was respected by the teams.
And had you made him aware of that consideration?
Yes, sir.
Now, as a mechanic at Disney, specifically when he went through the apprenticeship program, was he issued tools by Disney?
So there is a small set of tools that are issued by Disney. It's just a standard set that they're issued. However, each cast member is allowed the opportunity in order to be able to purchase and bring in their own set of tools. So those tools are can also be generic ones or specific for whatever task it is that they are performing in the attractions.
And even the tools issued by Disney once he completes the apprenticeship program, do they then belong to the individual?
That I don't recall.
Now, does Disney maintain records of employment that include absences, whether or not someone called in sick, didn't call in when they were absent, things of that nature?
Yes, sir.
Going to go ahead and show defense what has previously been marked as State's Exhibit U, proper business record certification, business records from Walt Disney work, Michael Shaver.
Judge, we're going to object to the objection, or to the certification, excuse me. The records are just improper bolstering at this stage. They're not relevant, probative. This witness has no probative testimony other than to try to bolster a man who's not here before. It's not probative pursuant to Smith versus Carlisle and Volker as well that I've cited to the court.
All right. State's response.
Any sort of objection to the business record certification is untimely, as it was not done for the business record certifications for these Disney records were not done prior to trial. And we are going to be talking about his attendance records, which are contained within.
It does not alleviate the relevancy, whether or not there's an objection made prior to trial or not. The state still has to show the probative value, irregardless of whether they want to introduce it. Under Smith versus Carlisle and Volker, it's not probative evidence to just bring a man in and try to bolster somebody's testimony to try to throw some ammunition out there on behalf of the state. Again, it's not probative in any matter.
Anything further?
No, sir.
Objections overruled.
States move in States U into evidence as States number 9.
Okay. States U will be admitted into evidence as States number 9.
Now, Mr. Borglum, prior to your testimony here today, have you gone back and reviewed Mr. Shaver's attendance records during the time frame that he was working at Disney?
Yes, sir, I have.
All right. Now, I want to take you back to November of 2015. Was Michael Shaver scheduled to work on November 10th, 2015?
Yes, he was.
And, Your Honor, I would ask at this time to publish the contents of States Number 9 to the jury.
Whether he was supposed to show up for work one particular day does not alleviate or does not answer the question.
Can we approach?
All right, let's have a sidebar. Thank you.
Is this the same objection again? So he allegedly raised the objection before trial. It was overruled. He already objected once. It was overruled. Now he's objecting a third time? Wow. This guy's awesome.
Orland, I'll direct your attention to the page that's numbered on the bottom. That's 986. Do you have that page in front of you?
Almost.
Okay.
986.
Now, on November 10th, 2015, was Mr. Shaver scheduled for work?
Yes, he was.
And did he show for his scheduled work?
November 10th, he's actually documented as a no-call, no-show, which means, so no-call, no-show means he was scheduled for work and he did not call in, whether it be call sick, call whatever, in order to let us know he was not coming into work.
And what was his next shift after November 10th, 2015?
So the prosecution is trying to establish here the time of death. And when this person showed up to work is relevant to determining the date of death. So all of these business records that show when he stopped showing up to work are relevant. And that's essentially what the defense attorney is objecting to, the relevance of these documents. He's saying none of this matters. How does it not matter? We don't know when this guy died because he was buried for 3 years. There's the coroner could not determine a date of death other than to say somewhere between months and years this person has been dead. We're trying to establish the time frame so that all the rest of the little pieces that the prosecution puts in place after we establish the time frame of death make a little more sense.
So it would have been November 10th, which actually would have been his first day coming back to work after his 2 days off. So November 10th, 11th, 12th, 13th, and 14th. So there's 4 consecutive no-call, no-shows.
And all of those are reflected in the records that you're referring to there?
Yes, sir.
And going back through his attendance at Disney, had he ever no-call, no-show for work before November of 2015?
No, he had not.
I'll just quickly go through those records, appearing on page 97, 98, 99, 990, 991. The first entry there on page 991 as far as the time frame that Mr. Shaver was working with Disney, where there was something on his attendance.
The one for 926?
On
Top one?
the date on 991 showing
The date on 991, the very first entry is 8/31/2009.
So in that 6-year period prior to November of 2015, no call, no shows.
That is correct.
Once Mr. Shaver had failed to appear for work and didn't call in, first of all, was that concerning and unusual to you based on his prior experience?
Yes, it was.
And so what did you do?
So the first night I would have actually asked the team members who know Mike best if they knew something was going on, if he had reached out to any of them, and I would have sent him a text message.
Did you ever call him on the phone?
Not the first night.
And how were you communicating with him then?
At that time, it was via text message.
And did he or someone in possession of his phone correspond back with you?
On the 13th was actually when I received a text back, because by the 13th that had been 3 consecutive no-call, no-shows. By Disney policy, 3 consecutive no-call, no-shows. It is a automatic termination of employment with a company. So I had been texting and trying to call his cell phone in order to find out what was going on, as well as if there was issues in order to offer assistance, because Disney does have Disney Assistance Program where if things are coming up, we're able to help out, especially for outstanding employees. So I had reached out to Mike, and on the 13th is when I got a text message back. The text message stated along the lines of...
Objection. Judge, we can approach.
All right, sidebar, please.
He's probably objecting as to hearsay because he's about to say what's in the text message as opposed to just introducing the text message. Of course, he's probably going to object to the introduction of the text message, saying it's irrelevant or some other nonsense. So let's just fast forward through this.
Objection, Judge.
Yes, sir.
That's inappropriate.
All right. Please proceed. Thank you.
Objection.
All right, so the judge overruled that.
Objection, Judge.
Yes, sir.
That's inappropriate.
All right.
That was a little inappropriate. The prosecutor says, as they leave the judges the bench from the sidebar, all right, so the judge overruled that, basically telling the jury this is another idiotic objection by the defense, and the judge saw through that idiotic objection. So here we are, back to me asking questions. That's
Please
inappropriate.
proceed. Thank you.
What was the response that you received?
So the response I received back was having issues at home in Georgia right now. Either fire me or I'll quit. I'm not coming back to work.
And his personal property being the tools were still at Disney?
Yes, sir.
Did he ever come back to get those?
No, he did not.
Did you ever reach out to Laurie Shaver to ask her?
So I don't know if you all just heard the defense attorney whispering to his client. The fact of the whisper was audible. That little microphone that's sitting at his table is always on unless he turns it off. There's a little button on that microphone that you have to hold down when you want to talk to somebody else at the table and it not be picked up by the speakers, by the microphone. And he didn't push that down. I don't know if he knows that he's supposed to or what, but that's typically what attorneys do, is they push that little button down, they hold it the entire time that they're whispering, and then they let it go at the end.
What to do about the tools?
No, I did not reach out to Laurie. I still continue to try to reach out to Mike. Part of the process that we have with the company, when somebody leaves the company, whether on their own volition or whether they were terminated, is their tools are their property. So we do not maintain or keep their property. So we make every effort in order to return the property back to them. Since Mike's toolbox was in the attraction, made every effort in order to return the toolbox. At that time, it was actually shortly after that, so it would have been early December, is when I received a snapshot of a message that Frank Merritt had received in order to turn the toolbox over to Frank.
Now, have you seen or actually spoken with Michael Shaver since November 7th of 2015?
No, sir.
Nothing further, Judge.
Mr. Wiggs?
Mr. Borglum, tell us about your IT experience.
IT experience, very minimal.
Do you? Do you hold any kind of degree in IT?
No, sir.
Okay. And when you say you received a message, you don't know who you received the message from, do you?
Other than the fact it comes up on the phone as the message for the caller ID showed it was Mike Shaver's cell phone.
Okay. Do you know where that was sent from?
No, sir.
Do you know what router it was sent from?
No, sir.
Do you know what Michael Shaver was doing 24 hours before he last showed up for work?
No, sir.
Do you know who he was with
No, sir.
the last 24 hours?
No, sir.
Do you know who was with Michael Shaver the last 24 hours?
No, sir.
Do you know where Michael Shaver was at?
No, sir. I do not. I would have assumed he would have been at home, but no.
That's your assumption, correct?
Correct.
Okay. Now, aside from the records that were introduced, did Michael have any complaints at work?
No, sir.
Okay. Was there a Kendall Davidowski? Somebody he was dating at work?
There is a Kendall Davidowski at Disney, but
Yeah.
I don't know whether he was dating her or not.
Do you know if she had filed any complaints against her?
Not that I'm aware of.
Okay. So you don't know if those are a complete statement of all the records on file with Disney, do you?
Yes, sir, I do.
Okay. And you don't know who Kendall Davidowski is?
I know who Kendall Davidowski is. She
Okay.
also worked for me during a period of time.
Okay. And you don't know whether or not Mr. Shaver had a relationship with her?
No, sir.
Okay. One moment, please, Judge.
Yes, sir.
That's all I have. Thank you, Judge.
Thank you. State?
Maybe excuse me.
All right. You may step down for the witness stand. You're released from further testimony, sir. Thank you and have a good day.
They call Brendan Burns.
Files are still there.
Yes, thank you. Please.
My name is Brendan Robert Burns. It's BRENDEN, Robert, ROBEERT, Burns, BURNS.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. Please proceed.
Or can you please introduce yourself to the jury?
Again, my name's Brendan Burns. I'm an airline pilot by trade, but at the time I was a aircraft mechanic.
Did you know Michael Shaver?
Yes, I did.
And how did you first meet Michael Shaver?
As I was an aircraft mechanic at Warbird Adventures in Kissimmee, Mike came in as a volunteer to help work on some aircraft projects, race airplane, etc.
And when you say he came in as a volunteer, what type of role was he wanting to volunteer to do?
As an aircraft mechanic, I guess any tasks associated with working on our race airplane, mainly.
And that area where he started to volunteer, did you start a friendship with Michael Shaver?
I did, yes.
And through that, did you meet his wife, Laurie Shaver?
Yes, I did.
Do you see her in the courtroom today? Can you identify her by something that she's wearing?
Yes, I do. She's wearing a tan coat.
Now, what types of things would Michael Shaver do for this reason?
Honestly, whatever was requested of him. One of the first things I remember him being sort of assigned to was we were building a new canopy for the race airplane, so he was molding some styrofoam for a mold of the canopy. So that was one of the first things I remember.
And were there times that his wife, Laurie Shaver, would also participate in the activities of this race team?
Yes.
And how would that come about?
Well, Laurie would attend the races, and she helped out in the merchandise booth. We sold T-shirts, hats, and other paraphernalia.
Did you ever go over to their home to visit or socialize?
Yes, I did.
And was there a period of time, in case I didn't ask, what was the period of time that you knew and were friends with Michael Shaver?
I believe it was late 2012 or early 2013 through fall of 2015.
And was there a period of time you were friends with Michael that he had moved out of the home and was living at the hangar?
Yes, yes.
What time frame was that?
He lived in the hangar, I want to say it was late 2014 or early 2015.
And during that time, was he separated from you?
Yes.
During that time that he was living at the hangar, did Michael Shaver start dating someone else?
Yes.
And who was that?
Her name was Kendall.
And was that somebody that also worked at Disney, to your knowledge?
To my knowledge, yes.
After a period of time, did you see Laurie Shaver start coming back to the hangar when Michael was living there?
Yes, I did.
And what types of things would she do when she would return to the hangar where Michael was staying and living?
Well, I saw her talk to Mike outside. One time there was some pizzas in the break room, and I asked, and someone said that Laurie had bought pizzas for the race team.
And after this period of time, in the summer of 2015, did Michael Shaver leave the hangar and return to live at the marital home?
Yes, he did.
Are you Facebook friends with Michael Shaver?
Yes, sir.
And have you, during the time that you've been friends and since his disappearance, been able to look at the pictures and things that have been posted on his Facebook?
Yes.
And here at this time, I'm showing the defense what has been previously been marked for identification. It states V, the Facebook records with appropriate business record certification, as well as 2 individual photos.
So he just testified that Mike was living in the aircraft hangar and that at some point he moved back home, and that was prior to the death. Now, the defendant has maintained that the last time she saw the last time Michael was at the house was well prior to this incident in November. And then that the last time she saw the defendant was at a custody hearing. So I think that this testimony is to kind of negate that line of reasoning, I guess, on behalf of the defendant.
Photographs labeled states X and states W.
We can approach.
Mr. White wants to approach.
All right. Sidebar, please.
These guys are approaching a lot.
You're at this time, based on business records, notice and certification provided by Meta, the state removed states V, the Facebook records of Michael Shaver into evidence in states number 10.
All right, states V will be admitted into evidence of states number 10.
Yes, same objection, Judge.
All right, sir, overruled.
Now, Mr. Burns, I'm showing you a photograph taken from those records that has been labeled as states W. You recognize this photograph?
Yes, I do.
And first of all, who is that a photograph of?
That's Mike Shaver.
And how do you recognize that photograph?
I recognize this photograph because I took this photograph.
And what was the circumstances that you took that photograph?
Mike and I were fishing behind my house that I lived at the time.
And when would that event have occurred?
This was in June of 2014, I believe.
And after you took that photograph, did you share that with Michael Shaver?
I'm sure I did, either via text or I tagged him on Facebook.
And at that time, did you have a working phone number for Michael Shaver?
Yes, I did.
And what was that phone number?
It's
Do you have it on your phone?
It's on my phone.
Looking at your phone and the entry that you have on your phone help refresh your memory about what his phone number was?
Yeah.
Did you ever change it at any time during your friendship since you had that number programmed and up till today?
I have not.
Okay. Can you go ahead and look at it, please?
Sure. The phone number that I have for Mike Shaver is area code 352-431-5121.
All right, this time the state will move State's Exhibit W into evidence, the State's Exhibit number 11.
Same objection, Judge.
So I've never permitted somebody to pull something out of their pocket and refer to it when they are my witness. If the other person's witness wants to do that, great. But you do run into the potential that now that you have talked about this object in your pocket, now that you have read something off of this thing in your pocket, now on the other side, I can say, okay, show me everything that is related to that as well. It probably wouldn't happen here, but it's just not necessarily something that you want to do on a regular basis.
Improper predicate.
Objections overruled. States W will be entered into evidence as States number 11.
Now, did you see this picture appear on Michael Shaver's Facebook?
Yeah, at some point.
And when was the last time you had any contact where you either saw or spoke with Michael Shaver?
It was early October 2015.
And when something is posted onto Facebook, when you're going through, does it have dates and things that correlate to that posting as you're looking at the post?
Typically, yes.
And I'm going to go ahead and present this exhibit that's just been admitted into evidence. When does this show that photograph was uploaded onto Facebook?
It shows it was uploaded March 8 of 2017.
I'll go ahead and publish for the jury. Is that the photograph that we've been talking about that's on the screen?
Yes.
I'm going to go ahead and show you another
Ladies and
photograph.
gentlemen of the jury, if you wish, you may get up from your seats if you would like to get closer to view the photograph. So feel free to move about the jury box, and if you need to, Deputy Olmsted will allow you outside of the jury box so you can view the photograph or any exhibits more closely. And that applies to all exhibits. Feel free to move about the jury box and out of the jury box as needed.
Showing you previously been marked as X, you recognize this photograph.
Yes, I do.
And how do you recognize that photograph?
It's a picture of some random bar somewhere that
Where
might
did you first see that photograph?
on Facebook.
And specifically, whose Facebook profile?
That was Mike Shaver's Facebook.
And when you saw that photograph on Mike Shaver's Facebook profile, why did that individual picture seem unusual to you?
Well, he's not in the picture, and I don't recognize any person in this photograph or the place it was taken.
And looking at that photograph, did you do anything to kind of look into where that photograph came from?
Not really. I mean,
But as the photograph that you were looking at from Facebook that was posted on his profile, you do not recognize Mr. Shaver in that or any other individual?
that's correct.
All right, this time the state removed states X into evidence at states number 12.
Judge, same objection. Is an improper predicate?
All right, sir. Objection is overruled. States X will be admitted into evidence as states number 12.
And does this photograph, which I'll publish, show when that was posted?
It says it was uploaded January 2nd of 2018.
And I'm publishing states 12 at this point.
All right, request to publish is granted.
So we now know that Mike was no longer alive when these photos were uploaded. One was uploaded on March 8th of 2017. The next was uploaded on January 2nd of 2018. And we know that he wasn't alive at that time. The state is trying to establish that it looks like somebody is trying to maintain the fiction that Mike was still alive. Who could that have been? Now, remember, they're later going to show that these Facebook posts happened with the same IP address as Facebook posts that were used to update Laurie's Facebook page. So unless somebody hacked into both Facebook accounts and were manipulating both of them without Laurie's knowledge that someone was manipulating her Facebook page, then it stands to reason that it was either Laurie or somebody in Laurie's house.
That is the exhibit itself. That's how it comes in. As far as the writing on it, go ahead and publish the physical exhibit to the jury.
Once you view that, the physical exhibit, please pass it around to the other jury members. Thank you.
Have you seen or spoken to Michael Shaver since November of 2015?
I have not.
Nothing further, Judge.
Mr. Wiggs?
May it please support?
Yes, sir.
Sir, this digital data went back between you and Michael, allegedly, correct?
I believe so.
Okay. You don't know who was on the other end of the router, correct?
That's correct.
You don't know if it was a male or a female, correct?
Correct.
You don't know how many people were in the residence, correct?
That's correct.
You don't know if it was intercepted anywhere, correct?
Correct.
You're not an IT personnel, correct?
That's correct.
Okay. Were you present during the demise of Michael Shaver?
I was not.
Do you know anybody that was?
I do not.
So this digital data is supplied to say, essentially, I saw him in this period, I believe, correct?
Yes.
I sent him something, I believe, correct?
Yes.
Do you remember Laurie Shaver's child, Herein?
No.
You don't remember that child?
No.
Okay. Did you turn over your computer to law enforcement?
No.
Did they issue a warrant to secure any information from your system?
No.
Very well. Thank you.
All right. Redirect.
Did you know any of Michael Shaver and Laurie Shaver's children?
Yes.
Who were they?
Isabel and I forget the little boy's name.
Any children that you had after Michael Shaver, would you have any way of knowing? And has there ever been any inference or discussion of any text messages or anything that you would receive from Michael Shaver on your computer?
Not that I'm aware of.
Nothing further, Judge.
Mr. Wiggs,
Nothing further. Thank you, Judge.
may the witness be excused from his subpoena.
Yes, sir.
All right, thank you for appearing today, sir. You're released from further testimony. Have a good day.
Thank you.
Okay.
The state calls Robert Mercado.
All right, good morning, sir. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to go. All set?
Yes.
Okay. Please state and spell your full legal name.
My name's Robert Mercado, Jr., R-O-B-E-R-T, M-E-R-C-A-D-O.
Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please proceed.
Can you please introduce yourself to the jury?
Hi, my name's Robert Mercado.
Did you know Michael Shaver?
Yes.
How did you know Michael?
We first met at work in our apprenticeship, mechanical apprenticeship, and from there on we hit it off.
When you talk about your apprenticeship at work, where did you?
At Walt Disney World.
And were you guys going through the apprenticeship at the same time?
We ended up at the same location. He was a year ahead of me.
How long is that apprenticeship?
It's a 4-year apprenticeship.
Now, through Michael Shaver, did you ever meet his wife, Laurie Shaver?
Yes.
And did you ever go over to their house to visit or socialize?
Yes, multiple times.
And in November of 2015, what kind of vehicle did you have?
I had a gray Explorer.
And in November of 2015, did you ever go pick Michael Shaver up from his home and take him anywhere so he could leave his family?
No.
Did you ever take him to Georgia and drop him off anywhere up there?
No.
Going back to November 2015, did you have any upcoming plans with Michael Shaver for later in the month?
Yes, we were planning on having Thanksgiving together.
And when you talk about having Thanksgiving together, who all was involved with that Thanksgiving?
It was going to be his and my family at his house.
And so when you talk about his and your family, would that include Laurie and his children?
Yes.
Did you have children?
Yes.
How old were your children in comparison to his?
Older. Mine are a lot older than his.
When was the last time that you physically saw or spoke in person to Michael Shaver?
It was at least a month before we were making plans for Thanksgiving.
Did you ever receive any contact about those Thanksgiving plans, either canceling it or doing anything with those plans?
Yes, I messaged him multiple times a couple weeks before just to solidify the event, and after that, he just texted me back saying that we were canceling it.
Was there anything unusual about your correspondence with him about that event after November 10th of 2015?
Yeah, he kind of just stopped talking to me and said he wanted to be left alone.
Was that out of character for him?
Absolutely.
And have you spoken on the phone, or any contact that you can verify was in fact from Michael Shaver since November of 2015?
No.
Nothing further, Judge.
All right, Mr. Wiggs?
Yes. Mr. Mercado, did you ever go over there, transport Mr. Shaver to or from the residence?
Yes.
Okay. What was that regarding?
Depends, really. Which time you...
Was there more than one time?
Yeah, I used to go over there all the time.
Was there any time that you transported, removed any goods of his, any items of clothing with him when he was leaving the residence?
The one time I picked him up from court and took him to his residence.
To obtain some things?
Yeah, to pick up his...
Okay. And were you there at any time when there was any violence between Mr. Shaver and Miss Shaver?
Yes.
Okay. So you witnessed that?
Yes.
And there was a 911 call, correct?
Not at that time, no.
Okay. Did you have to get between Mr. Shaver?
I had to get between both of them.
Okay. When Mr. Shaver left the residence, do you know where he resided?
I took him home with me that night, and then the following day, he stayed at the Warbirds Museum hangar for roughly the better part of a year after that.
Okay. Did you witness any homicide in this case?
No, sir.
You know what Mr. Shaver was doing 24 hours before his death?
No, sir.
Do you know who was present with Mr. Shaver
No.
4 hours before his death?
No, I do not.
One moment, please, Judge.
Yes, sir.
He continues to whisper with his client. This time, it sounds like the court cut off all the audio in the room so that nobody could hear anything, because we could hear what he was saying to the client. He specifically asked his client if there's anything else that he wants that she wants
Some
him
of
to
his stuff
ask.
so he can
witness.
leave the residence. And while he was doing that, I started to hear arguments, and they started fighting. Just arguments. And at that time, when I walked in, I noticed that she had a gun in her hand, and she was waving it around saying she was going to hurt herself. So I separated them, removed the weapon from the area, consoled her and tried to calm her down while he got the rest of his stuff, and then we left.
So when you're referring to some violence that you observed between them, you never saw Michael Shaver touch or strike Miss Shaver in any way?
No, he would never.
The only thing that you saw was Miss Shaver brandishing a weapon and making threats?
Yes.
Nothing further?
Mr. Wiggs?
Why did the defense attorney, even bring up this violence issue if the alleged violence happened was perpetuated by his counsel, his defendant, his client was being violent against the decedent? Why would he even bring it up? The prosecution didn't bring it up. Why did he open the door to that?
911 call?
Not that I'm aware of at that time, no.
Okay. Did you see anything happen to Mr. Shaver?
Not that night.
Okay, Mr. Shaver was acting aggressive on that night, correct?
They both were.
They both were, okay? And Mr. Shaver's the one that left the residence, correct?
Yes, I took him with me, yes.
Out of his necessity because of his act of violence, correct?
It was for the betterment of both of them that he left.
He left by law, correct?
Not that night, no.
Not that night, it was a different night?
It was the previous night.
I see, okay. And you came to retrieve his belongings with him, correct?
Yes.
And he was acting violent at that time?
No, he was not.
Okay. You just stated you got in between the two of them
Yes.
because they were acting violent, correct?
While he was trying to retrieve his stuff, yes.
Okay, thank you.
Nothing further, Judge.
All right. And may the witness be released from his subpoena.
Yes, sir.
Okay. Thank you for testifying here today. You're released from any further testimony. Thank you and have a good day.
It sounds like the defense attorney doesn't have all of his facts in order as to what days certain things happened on. And so he's asking questions and he's looking like a fool in front of the jury. But
State calls Corey Lutzow.
Good morning. Please come up to the witness stand. Please make yourself comfortable. Let me know when you're ready to go. All right, sir. Please raise your right hand. Please state and spell your full legal name.
My name is Corey J. Lutzow. It's spelled C-O-R-Y. Middle name is J-A-Y. Last name is spelled L-U-T, Z as in zebra, O-W.
All right. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I swear.
All right. Thank you, sir. Please proceed.
Can you please introduce yourself to the jury?
My name is Corey Lutzow.
Did you know Michael Shaver?
Yes, I did.
How did you know Michael Shaver?
I worked with Michael Shaver at Disney, at Epcot, at the attraction Spaceship Earth.
And approximately when did you start working with him?
Roughly about spring of 2015, when I transferred from being an attractions cast member to a mechanic.
And at that point, had he already gone through the apprenticeship program?
Yeah, actually, he had just graduated the apprenticeship program.
And as a mechanic over there, were you working at the same attraction with him, a different attraction? How was that?
We were working at the same attraction. I was actually introduced to Mike on my first day on the job. He was going to be the guy that was actually showing me around the attraction and getting me acquainted with everything.
And would you ever visit or socialize with Michael Shaver outside of work?
No. We messaged a couple times on Facebook, text message here or there, but never really got the chance to socialize outside of work because with my stint in the military, I was always busy going between Disney and doing the military thing, so never really got a chance to socialize outside of work.
Did you all work the same shift?
Yes, we had the same days, same working days, same days off.
And what shift was that?
So our shift was third shift, and we had Sunday, Mondays off. So we would usually come in on a Tuesday night, and then we would clock out early Saturday mornings for our weekends.
Where do mechanics at Disney get their tools from?
So during the apprenticeship program, when you go through the apprenticeship program, you get your tools assigned to you, and then you get to keep those upon graduation. And then if there are any other specialty tools that you would like to buy, we have a Snap-on and a Mack truck that will come around usually on Wednesdays. So if you want to make any personal purchases, you can do so.
Now, when you purchase these from the Snap-on or the Mack truck, if you get better deals than if you go into like Home Depot or something like that?
Give or take. A lot of the times, I know me personally, me and Mike, we actually ended up buying like the same product. They had a deal where you can get a 1/2-inch impact, a 3-inch impact, with battery packs, whole 9 yards. That usually would retail about $1,500–1,600, and we ended up getting them for like $700–800.
Now, as someone who worked on the same attraction in the same shift as Michael Shaver, were you familiar with the tools that he had?
Yeah, his toolbox was right next to mine.
And do you have similar tools to what he has?
Yeah, generally. So with the attractions, with the apprenticeship program, they give them what they classify as a basic tool set. I don't exactly know how many pieces were in that tool set, but both his set and my set were almost identical.
And what kind of condition was his tools in?
I mean, just normal wear and tear, but he took pride in his tools just like mine. I mean, they were strategically placed, very well marked, so it was easy to find if we needed to borrow each other's tools.
And as far as the cost of these tools, you said you had very similar workup in your kit?
Mm-hmm. Exactly.
And so you are familiar with the value of the tools through your own personal experience?
Oh, 100%. I keep track, very accurate track of how much I spend on my tools.
And what is a rough estimate of the tools that Michael Shaver had at Disney that you had an opportunity to observe and were comparable to yours?
I would probably say his toolbox comparable to mine was roughly between $3,000 and $4,000 worth of tools.
When was the last time that you had any contact with Michael Shaver?
Last contact I had with Mike was the weekend he went missing, which I would say probably like around the 12th and 13th of November of 2015-ish.
At this point, are you given an estimate of that date?
I believe so, yeah. It's been so many years since it's happened.
Was your last contact with him at work?
Yes, we had clocked out of work, and we usually all walk to the parking lot together, and we all say, hey, we'll see you on Tuesday. And then they're like, and everybody reciprocates, and then we all go on our merry way.
If the work records indicate that the last day that he worked was November 7th, would that then have been the last day that you had contact with him?
Yes.
And you said you guys worked the same schedule, same shifts?
Mm-hmm.
So the November 10th being the next day he was supposed to come in at work, was he there?
No, he was not.
Did he ever return to work?
No, we did not see him.
Had you ever tried to reach out to him after he stopped showing up to work?
I reached out to him that Wednesday, so the second day he did not show up for work. I reached out to him via Facebook and said, hey man, just checking on you to make sure you're good. Never got any response, but I did get a read receipt, because if anybody knows social media, if you're on Facebook Messenger, their little icon will drop down showing that it's been read, and it showed it was read.
Objection. Judge. He's testifying. Excuse me.
Sidebar, please.
The prosecution is saying, look, Mike left $3,000 to $4,000 worth of tools at Disney that belonged to him. If he was quitting, why would he do that? He must have been dead. I think they've done a pretty good job so far of determining, the date of death. I think that we can infer at this point, it's a very reasonable inference that Mike was killed somewhere around November 10th of 2015, given that he did not return to work and was not seen by anyone at any point thereafter.
Icon that shows your profile after I had sent.
Mr. Bledsoe, please describe to the jury how, in your personal experience, you had knowledge that message was received.
So, when I opened my Facebook Messenger after I had sent the message, I had noticed again the little icon that shows your profile photo had dropped down, and it showed that it had been read. Usually when you open a message and it hasn't been read, the icon still remains high. So I saw that the message had been read, but I did not receive any messages responding to what checking in on him.
Did Michael Shaver ever return to Disney to pick up those tools that you talked about?
No, he did not.
Have you seen or spoken to Michael Shaver since that time that you all left work on November 7th, 2015?
Nope, did not. I've not seen him or spoken to him.
Nothing further, Judge.
Mr. Wiggs?
Sir, you don't know how Michael Shaver died, do you?
I heard about how he died, but
Right?
but I don't know 100%. No.
Okay. What you're going on is speculation, correct?
I guess you can say that.
Right. You were not present witnessing the demise of Michael Shaver, did you?
No.
Okay. You don't know who responded to any email that you may have sent to Michael Shaver.
I never said I sent an email. I said I sent him a direct message via Facebook. That's not an email.
Right. In the form of an email, communication, correct?
Again, that's not an email.
Okay.
It's a
communication.
It's a communication. It's a direct message, almost like a text message.
And you're not an IT guy.
Never claimed that to be that. No.
I didn't say you did claim to be, but you hold a degree in IT, correct?
Nope.
You don't know who was at any location that may have intercepted that, correct?
No.
Thank you. Let me ask you one more question. You know what Kendall Davidowski?
I've heard of the name, but I've never met her.
She worked at Disney?
My understanding is she worked at Disney, but she was not in my location when I was there.
You know if Mike was dating her?
Nope. Again, all I know is I heard of the name, but that was it.
Okay. Do you know anybody Michael was dating?
Nope. We never talked about that.
Thank you.
State?
Nothing further. You can be excused.
All right, sir. Thank you for appearing today. You're released from further testimony. Have a good day.
Thank you, sir.
State called Brian Shaver.
These two could not stop whispering to each other.
Oh, Judge, I think we might want to dismiss the jury for a moment.
Yes, sir. All right, we'll take the jurors out for a comfort break. We'll be in recess for about 5-10 minutes. Thank you.
I don't see where this really going.
I think they're about to start questioning this witness
Please be seated, sir.
about whether he was in the courtroom yesterday.
Please state your name for the record and spell your full name.
Brian Shaver, Brian Shaver.
All right, please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, nothing but the truth, so help you God?
Yes, I will.
There are a few preliminary questions that I'd like to ask you. Were you in the courtroom yesterday?
No, sir.
Okay. Have you discussed your testimony with anyone?
No, sir.
Okay. Has anyone discussed their testimony with you?
No, sir.
Okay. Have you done any research regarding the case?
No, sir. Well, yes, I have in the past, not recently.
How long ago?
Just kind of keeping a little current with it, but I wouldn't say recent.
Okay. And have you viewed anything in the media recently?
I saw it on the news last night, just
Okay.
on the local news, but that was it.
All right. And State, do you have any questions?
Mr. Shaver, you didn't watch the live stream or anything?
No, sir.
That were covered?
No, sir.
When you talk about research, you're following news media to follow along with your brother's case?
Yes, that is correct.
Nothing further, Judge.
Mr. Wiggs?
Did you see something on the news last night?
I saw about the court proceedings, about the jury selection and stuff.
Okay. Had the state communicated with you about the obligation not to be communicating with other witnesses or reading any data?
Yes, they did.
When did they do that?
It's probably been, I think, probably about a month ago.
All right.
Anything further?
Yes.
Okay. All right.
Any bet the defense is going to say he watched the news last night, the local news, and there was a 3-minute clip about this trial on the local news, and so he shouldn't be allowed to testify today because he knows what happened yesterday. I doubt that the court is going to sustain that objection, and the court is probably of the opinion that go ahead and bring it up on appeal. See how you fare there.
All right. Are the parties ready for the jurors, or would the parties like a comfort break?
I was going to suggest that we're kind of at that 10:15 route.
Yes, sir. Let's take a 5-minute comfort break. All right. We're in recess. Thank you.
All right, everybody. They're going to take a comfort break. I'm going to take a comfort break as well. So just give me a little bit, and we will come back, and I'll fast forward to wherever the court picks up.
Thank you, sir.
All right, I'm back. Thankfully, before Natalie left, she made me a pot of coffee. She's wonderful, isn't she? So as Tread has pointed out, I'm going to need coffee in order to make it through cross-examination with this particular attorney. So I am glad to say that I have a new cup and I am ready to proceed. You guys ready? Here we go. Let's get to the end of this break.
Narrative and emotional state of they had no knowledge of who he was.
Why aren't they turning their microphone on?
They didn't look at his coworkers. They looked like crap. And his family didn't care. They didn't know what he was up to.
Has this defense attorney never been in court before?
You may be seated. I see that all members of the jury have returned. And before we begin, I have a few questions for the jurors. Have any of you spoken with anyone about the case? Okay. If you have, please raise your hand. Okay, I see that no hands were raised. Have any of you done any research about the case? If you have, please raise your hand. I see that no hands were raised. Have you viewed anything about the case on the TV or heard about it on the radio or otherwise? No. Okay. All right. If you have, please raise your hand. I see that no hands were raised. And all right. Anything from the state? Anything from the defense?
No, Judge.
All right. Thank you. All right. Please proceed. Thank you.
Brian.
All right. Good morning, sir.
Morning, sir.
Please state and spell your full legal name.
Brian Douglas Shaver, Brian Douglas Shaver.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
My name is Brian Douglas Shaver. I was the brother of Michael Douglas Shaver.
And are you his older brother or younger brother?
I'm the oldest.
How much older are you?
I'm actually 13 years older than Michael was.
And were you still living in the home when he was born?
Yes, I was.
And was there a period of time where you grew up together?
No, my parents got divorced when I was about 15 years old, so Michael was only a couple years old. Now, we spent a lot of summers and Christmas breaks and stuff like that together, but not really under the same roof.
So after the time frame that your parents got divorced, then did Michael stay with one parent and went with the other?
Yes, I went with my father and he stayed with my mother.
And during holidays and summers after that, is that when you're talking about?
That is correct. That is correct.
And you know Laurie Shaver?
Yes.
Okay. Had you met her through Michael?
Yes, through Michael.
And about when did you first meet Laurie Shaver?
It was after they got married. They had moved to Florida. They had moved to Florida on 2 different occasions. It was the first time that I had actually met her.
And prior to his death, how often would you talk or see Michael Shaver?
They actually came to my house in Georgia 2 or 3 4th of July's. We'd have a cookout and kind of a family get together, and then we'd talk occasionally through telephone call or text.
And in 2015, were you living in Georgia then?
Yes, I was.
And was July of 2015 the the last time that they came to visit you for one of those 4th of Julys?
No, it should have been. It was probably around 2012, 2011 or 12. I'm not sure exactly the year.
During the time frame after that 2012 visit, up until the time frame where Mr. Shaver disappeared, how would you communicate with him?
Primarily, I know I had a couple phone calls with him, primarily text or Facebook message.
And was there a time frame where you just were not able to get in touch with him?
Yes.
And when was that?
Probably started in late 2014.
And after November of 2015, have you been able to have any sort of was there a period of time where you started to worry about his whereabouts?
Yes, when there was no contact, my mother had gotten sick, was in the hospital. We couldn't get a hold of him to let him know, about her sickness.
How was the family reaching out to let him know about his mother's sickness?
We called, text, Facebook message, Facebook, on the wall, whatever you want to call it, and tried to call, but like I say, and left voicemails, but there was no return.
And what period of time was that?
I really don't recall on that. Probably close to 6 months.
What year are we talking about?
I believe it was 2015, but I'm not 100% sure on that.
And would you respond to any of that?
No.
And have you seen or spoken to Michael Shaver since November of 2015?
Well, I received some text messages, no, let me rephrase that. I received some Facebook messages from what I believed was Michael, but at the time we didn't know he was missing, and I assumed that it was him.
And anything about the tenor of those messages that caused you any sort of concern?
No, not at the time.
All right, sidebar, please.
There's nothing.
Anything about the tone or tenor of those responses that gave you concerns?
No, there was one particular one that, I assumed that it was him because there was nothing evident at the time that he had asked for my mother's phone number, our mother's phone number, and said that he had tried to get a hold of her. It was much after she was sick, and asked me if it had changed, and I texted back and said no, that it hadn't changed, and gave the phone number again just to make sure that he had the correct one. But that was I think that was the last communication I had.
A brief recess at this time. Apparently, electronic court reporting is having issues with recording the proceedings. So until that has been corrected, we'll resume after it has been corrected. All right. So please take out the jurors. Thank you. All right, please be seated. I see that all of the members of the jury have returned. Thank you again for your time and patience today. Please proceed.
Mr. Shaver, is it fair to say that your contact with your brother over the years was not frequent?
No, I'd say it was more occasional than frequent.
And the various occasional responses that you and other family members may have received in 2015 and 2016 through Facebook or other sources such as that, did that alleviate initial concerns that something was wrong with Michael?
Not to me, because I felt that there was communication, even though it was very limited. But that kind of took, the worry that he was, something was wrong.
Nothing further, Judge.
Mr. Wiggs.
Mr. Shaver, have you ever been to your brother's house?
No, sir, I have not.
Never even been there?
Nope.
So when we talk about communications, we're not talking about many communications, are we?
I mean, telephone and, visits.
Yeah. Did you call Laurie Shaver?
No.
Any concern?
No.
Never thought to pick up a phone and call her?
No.
You stated this surfaced around 2014?
I believe so.
Okay. And how long did this go on before you thought something may be up?
I mean, when the communication stopped, we began to really worry that what happened to him. Where did he go? Did he disappear? Did something bad happen to him?
How long? What was that period of time that you said, hey, maybe we need to do something?
Probably a year.
A year, okay. So was it in 2016?
I don't recall.
You don't recall. Okay. And so you never pick up a phone and call Laurie?
No, I didn't even have her telephone number.
Okay. That's how close y'all were, correct?
I was not close with Laurie, no.
Okay. And you're not present, sitting here telling the jury you witnessed any kind of homicide, correct?
No, I did not.
Okay. You don't know what Michael was, who he was with the last 24 hours, correct?
No, I do not.
You don't know about any altercation that transpired, correct?
I know of a previous one, yes.
Okay. You know of a previous one. Okay. Did you witness this previous one?
I did not.
Okay. And so you don't see any kind of altercation. You just say, hey, we heard from Michael the last around 2014, correct?
Correct.
And sometime thereafter, I don't know, we became a little concerned, correct?
Correct.
And yet we never call Laurie, correct?
I did not myself personally.
Right. Thank you.
All right, State.
Nothing further. You may be excused.
All right, sir. Thank you for appearing today. You're excused from further testimony. Have a good day.
State called Douglas Shaver.
That entire testimony was pretty unhelpful, I think, to either side. We didn't establish much.
Good morning, sir. Please come up to the
I think the prosecution is trying to show, the decedent's contact with his family was sporadic, and that's why his family didn't raise any alarms when he went missing. That's probably the best that they got out of that witness.
witness stand. Please be seated. Let me know when you're ready to go.
Okay.
All right, sir. Please state and spell your full legal name.
Douglas Shaver, DouglasShaver.
Please raise your right hand. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Please introduce yourself to the jury.
My name is Douglas Shaver.
And did you know Michael Shaver?
Yes, he's my son.
And how many children did you have?
I have 4.
And where is Michael?
Michael was he would have been next to the youngest.
At some point while he was a child, did you and his mother divorce?
Yes, we did.
And what type of contact would you have with Michael Shaver after that?
He would. I would have him during the summer months. I'd have him flown down, and then I'd usually have him at Christmas time.
What kind of contact would you have with him once he became an adult?
It was limited.
Did there come a period of time in 2014 where Michael was not living with his wife, Laurie?
I really don't know.
And was Michael ever in the military?
No.
After November of 2015, did there come a time where the family started being concerned about Michael Shaver's whereabouts?
Yes.
And can you describe the things that the family started to do once they became concerned?
Just the I'm not much into texting, and basically what I was told from other family members that we're texting back and forth.
Objection. Judge hearsay.
Sustained.
My question specifically was, what types of things was the family doing once not why you all were concerned, but what types of things were done once the concern began?
Then they just started searching and contacted the sheriff's department.
Were you able to have any sort of contact, either talking to Mr. Shaver on the phone or speaking to him in person after November of 2015?
No.
And once the body was discovered in the backyard of the Shaver residence, did law enforcement contact you about that discovery?
I was down there.
And were you present, and did you submit a DNA sample to law enforcement for future comparisons?
I did.
Nothing further, Judge.
Mr. Wiggs?
Mr. Shaver, you were relatively estranged from your son, were you not?
For a period of time.
Period of time. When did you guys have this reunification?
Pardon me?
When was there ever a reunification between the two of
I really don't understand the question.
you? When did you guys get back together? Get reunited?
Okay. In approximately September of 2014.
14. Ever even been to the Shaver residence?
I've never been there.
Okay.
Except the day that when they discovered his body.
Okay. And you live where? You live where?
I live in Georgia.
Okay, so you're up in Georgia, you have some reunification, you never went to the Shaver residence, correct?
That's correct.
Okay. I'm going to ask you an obvious question. Obviously, you never observed a homicide in this case, correct?
That's correct.
Okay. You don't know how Michael died the night of, or day of his death, do you?
Do I not know how he died?
You did not observe anything.
Oh, no.
Okay. You don't know who was present.
That's correct.
Okay. You do not know who was involved in any event leading to the demise of your son, correct?
That's correct.
All right. I have no further questions, Judge.
All right, redirect.
Nothing further, Judge.
All right, thank you, sir. You're released from further testimony. Have a good day.
Thank you.
State calls Christine Corte.
Good morning. Please come up to the witness stand. Please be seated and make yourself comfortable. Let me know when you're ready to go. Okay. Please state and spell your full legal name.
Christine Corte, Christine. Last name Corte, Quarte.
Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Please introduce yourself.
Good morning, I'm Christine Corte, Michael's sister.
And you said you're Michael Shaver's sister?
Yes.
And was he older or younger than you?
Older.
Were you the youngest of the family?
Yes.
And how much older was he?
8 years.
Did you grow up in the same home with him?
So when they had that objection earlier this morning regarding people in the courtroom, Christine Corte's name didn't come up. And if you heard any of the whispering going on between the defense counsel and his client, she was saying, I've never seen her before. So ostensibly she could have been in the courtroom yesterday, and the defendant may not have recognized her as one of the potential witnesses in this case. And so she could at some point object regarding that if she's one of the people that were in the courtroom yesterday and the court didn't ask her any questions regarding, were you here yesterday? Have you heard anything? Have you listened to anything? All of that stuff.
We did not, but he came down for the summer, and I spent a lot of time with him during the summers.
Did you know or meet Laurie Shaver?
Very briefly when I was a young child.
And where would you have met her? What state were you in?
New York.
And in 2014, how often did you communicate with Michael Shaver?
In 2004,
One moment, please.
He's asking about New York, or she responded with New York. Before the Shavers moved to Florida, they were in New York. They lived in New York, and apparently Laurie was having an affair with somebody in New York. So Michael said, all right, we're going to move. We're going to pick the family up, move them down to Florida to kind of get away from this situation. And apparently that didn't help matters. She just allegedly had affairs in Florida instead.
Overruled. You may answer.
In 2014, how often would you communicate with Michael?
I talked with Michael a lot through text and social media, and we talked a lot about the family and just catching up and everything.
And would you talk to him on the phone or anything like that? Or was it mostly Facebook and text?
It was mostly Facebook and text.
And did you become engaged in 2014?
Yes,
Did you reach out to let Michael know about it?
I did.
Was he able to attend the wedding?
He was not.
Was there a period of time where the communication that you had with him changed?
Yes.
And can you describe the period of time that happened and how it changed?
Yeah, so I initially told him about the wedding and that I was very excited for him to join. We would have all our siblings together. And then his tone started changing, and it was harder to get a hold of him, and I could tell that there was a change in his tone.
Was there ever a period of time where you stopped being able to communicate with him as often as you had previously?
I sent some messages and text, and he wasn't responding.
And was that normal?
No.
So previous, anytime you had sent messages, he would respond?
Yes. Mm-hmm.
And sometime after 2015, that all stopped?
Yes.
Have you seen or spoken on the phone or in any other way where you could physically confirm that you were speaking with Michael Shaver since November of 2000?
No.
Nothing further, Judge.
Mr. Wiggs?
This was not a lengthy relationship with your brother or stepbrother, correct?
Yes, I've known him my whole life.
Pardon me?
I have known my brother my whole life.
Okay. Have you been in communications with him your whole life?
Yes, when he would come to our home for spending time with us during his trips, and then I communicated with him during all different methods: phone, text, social media.
Okay, social media. How long did you communicate with him on social media?
As long as social media has existed.
Okay. And you supplied the state all those records?
Yes.
Okay. So they have those?
Yes.
Correct? And they showed your communications?
Yes.
And those go back, what date? Do you know?
As long as social media has existed.
All right. Do you know if those have been verified through valid IP addresses, links, in any form or manner?
I imagine when the records were obtained, they are verified because they're coming from the source. Yes.
Okay. So when Mr. Shaver quit speaking to you, you just stated no change, correct?
There was a change in his tone. There was unresponsiveness, especially following 2015.
Okay. When was the last time you went to the Shaver?
The Michael Shaver residence, when we were called to inform that they had found his body, I went with my father.
So you never even met him, correct?
No, we were never invited.
Did you even know Laurie Shaver?
Yes.
Okay. When did you meet Laurie?
When I was a child, I had met her briefly in the state of New York.
So that's a long time that's taken place, correct, in this past?
Yes.
When Michael wasn't responded, did you pick up a phone and call your dear friend Laurie Shaver?
No, I did not have a relationship with Laurie Shaver.
Okay. You know even the Shaver children's names
I do.
through your communication with your stepbrother?
I have met the children.
I don't think that the condescending way he's asking these questions. Did you pick up the phone and call your dear friend Laurie Shaver? She's not testifying that she had a relationship with Laurie Shaver. She said she met her once when she was a child. He's being very condescending toward the witnesses, and these are the decedent's family members. I don't think the jury is going to like that.
Isabel and Aiden.
Their ages.
It's been, I think she's 16 now, and Aiden would be a preteen.
What's the last time you talked to Isabel?
In 2020.
2020?
When we were allowed communication.
Okay, 2020 when Laurie was arrested, right?
And we were granted communication, and we spent time with them here.
When y'all sought to gain custody?
No, when we sought to have an opportunity to have a relationship with them.
Did y'all retain attorney to seek custody? Objection or no?
Sidebar, please.
Whether or not they retained an attorney to seek custody of their brother's children after she had been in jail for having killed their brother, and after their brother was found buried in her backyard under cement, is irrelevant to this case. Totally irrelevant. I don't think that this objection is well-founded. I mean, I think this objection is well-founded. I don't think...
About gaining custody of these children?
I don't think any of this has anything to do with the case. Absolutely nothing.
Did not pursue gaining custody.
Anybody in your family?
We did not pursue gaining custody, but out of fear for the lives of the children, a discussion was after she's been arrested. We wanted to learn our options to make sure that the children were protected and cared for.
Thank you. I have no further questions.
All right, State? All right, may the witness be released from her subpoena?
Yes, sir.
All right, thank you for testifying here today. You're released from any further testimony. Have a good day.
State calls Desiree Snyder.
Good morning. Please come up to the witness stand. Please be seated and let me know when you're ready to go. Make yourself comfortable, please. Thank you. Are you all set? Okay. Please state and spell your full legal name.
My name is Desiree Ruggles, Desiree Ruggles.
Okay. And if you could speak up a little louder and get as close as you can to the microphone, everything has to be recorded. Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
Please introduce yourself to the jury.
Hi, I'm Desiree Ruggles.
And when I had called you as a witness, I had identified you as Desiree Snyder. Was that a previous name of yours?
Yes, it was my maiden name.
When were you married?
August of 2014.
Did you know Michael Shaver?
Yes.
How did you know Michael?
He was my uncle.
And which of his siblings are you the daughter of?
Stacy Turner.
And did you know Laurie Shaver?
Yes.
Had you ever met her?
Yes.
And prior to Michael's death, how often would you communicate with him?
Never. With him?
Yes.
When I was able to.
Did you communicate with him at all about the time frame where you were getting married?
I don't remember, honestly.
Did you send an invitation?
I don't believe so, but I don't remember.
Had you had communications with him after you were married?
Yes.
And he was aware of the marriage?
Yes.
And therefore aware that your name had changed from Snyder to Ruggles?
Objection.
Yes.
Leading judge.
Overruled. Please proceed.
So he would be aware of that?
Yes.
Now, in 2015, where were you living?
I was living in Lawrence at the time.
I'm sorry, where?
In Lawrence, New York.
Was there a period of time in 2018 where you reached out, 2016, where you reached out to Michael Shaver in attempts to communicate with him?
Yes.
And how did you do that?
Facebook Messenger.
And when that communication occurred, would that have been after the wedding?
Yes.
And after your name change?
Yes.
And when you sent that message, was that through your profile?
Yes.
And so it would have reflected your name of Desiree Russell at that point?
I had gotten a new Facebook, so it might have been from my previous.
I'm going to show what's previously been marked as State's Exhibit Y. I'll show that to the defense.
She doesn't remember which profile she used, so he's going to show this to her to refresh her memory. And of course, the defense is objecting. My guess is this shows that she used the Ruggles name, and whoever responded had no idea who Ruggles was, because allegedly the decedent's wife was the one responding as if she was the decedent.
Nice.
I do not envy Judge Rada in this case at all.
Charles, I'm showing you communication sequence of Y. Do you recognize this communication thread between yourself and the Facebook account of Michael Shaver?
Yes, I do.
And had you reached out to Mr. Shaver in 2016, and is that reflected there in those messages?
Yes.
And is that an accurate documentation of the messages that you sent and received from the Michael Shaver Facebook account?
Yes.
At this time, the state moves states Y into evidence.
Same objection, Judge.
States number 13.
The objection is overruled. States Y is admitted into evidence as states number 13.
Now, I'm going to go ahead and start you with the message, first message that was sent here on August 15th, 2016. Was that message from you?
Yes.
And what was the content of that message?
I was just saying hello to my uncle.
Go ahead and read it directly to the jury so they can see it.
It says, "Hey, Uncle Michael."
And above that is the response that you received.
Yes.
And what was that response?
Who are you?
And did you respond to that?
Yes.
And what was your response?
I'm your niece.
Did Michael Shaver's Facebook account respond to you when you said that you were his niece?
Yes.
And what was that response?
I don't have any family anymore. I have no clue who you are. No, stop messaging me.
And that message appears to have been sent on September 20th, 2016?
Yes.
Go ahead and present to the jury.
Yes, sir. Granted.
realize that the jury can see her smiling while the decedent's niece is on the stand in here? I don't know what the prosecution is doing right now. Probably looking to see if he has any further questions.
And the last time you saw Michael Shaver was what, 2001? That era time?
Around there.
Around there, okay. He was relatively estranged from his father, correct?
I don't know.
No, you don't know, okay. You made no trips to Florida, correct?
No.
You never went to the Shaver residence, correct?
No.
Michael Shaver was pretty much on his own outside the family, was he not?
No.
There were no visits, no homecomings, correct?
When he would visit us.
When was the last time you saw him? About 2001, correct?
Yeah.
Okay. Now, we've seen your email thread that's moved into evidence at this stage. Do you know the physical address it went to?
His Facebook profile.
Could it not be somebody at Starbucks using his account? Could have been, could it? Reasonable?
Yeah.
Right. Could have been somebody in Michael Shaver's house other than Michael Shaver, correct?
I mean, I guess.
Yeah. Could have been Michael Shaver himself, correct?
Yes.
Right. Thank you.
No, it couldn't have been Michael Shaver himself. Michael Shaver was dead. He was beneath cement in his wife's backyard. It could not have, all the people in the world that it could have possibly been, we know that it could not have been Michael Shaver. It couldn't. It's impossible. It's not possible.
All right. May the witness be released from our subpoena?
Yes, sir.
All right. Thank you for appearing today. You're excused from further testimony. Have a good day.
State called Stacy Turner.
Okay. Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to go.
I'm ready.
All right. Please state and spell your full legal name.
Stacy Turner, STACIE-TURNER.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please proceed.
Did you know Michael Shaver?
Yes, I did know Michael.
How did you know him?
Michael was my younger brother.
How much younger was
He was 11 years younger than I was.
he? Did you know Laurie Shaver?
Yes, I did.
And when did you first meet Laurie Shaver?
I met Laurie, I believe she was in kindergarten, and she grew up with Michael, so I've known her for quite a long time.
And did Michael Shaver and Laurie Shaver start dating when they were in high school?
They were in 7th grade when they began dating.
Prior to his death, how often would you communicate with Michael Shaver?
I would communicate with Michael every couple weeks to a month. Sometimes it was every other month. It kind of varied. You know, if we had a lot of news to share, we'd talk more often. If we didn't have a whole lot of news to share, we'd talk a little less.
How would you communicate with them?
Phone, text message, Facebook Messenger.
And did there come to be a time frame where you were not able to get in touch with them?
Yes.
And when was that?
The first time I was not able to get a hold of him was December of 2015. I believe it was December 4th.
And was it unusual for him to not respond to you?
For this particular message, yes.
Okay. And what was that message about?
My mother had become very sick.
All right, sidebar, please.
Who'da thunk it? Another objection.
All she told me were always very
Unusual for him to not respond to you?
For this particular message, yes.
Get a response to that message in December of 2015?
My mother was sick. She was in the hospital. We were not sure if she was going to make it or not. And Michael and my mother were always very, very close. And I sent a message saying that he was very sick. I never got a response, so I did reach out to Laurie, who I did get a response from.
Did she tell you anything about Michael's whereabouts?
All she told me was that she would tell Michael that my mother was sick.
Did you ever hear anything from Michael after you reached out to him about his mother's sickness?
No.
Did you reach out either through phone, text, or Facebook message after that in order to check in on Mr. Shaver?
Yes, I did at various times, and I would not receive any response.
Have you seen or spoken to Michael Shaver since November of 2015?
No, I have not.
Nothing further, Judge.
Mr. Wiggs?
Ms. Turner, did you witness any homicide?
No, I did not. I live in New York, and they lived in Florida.
You don't know what happened there or any homicide?
No, I don't.
Correct.
No.
You never saw any altercation, correct?
I never saw any, no.
Okay. So here you're testifying as to a timeline when you last spoke to what you believe you spoke to was your brother.
Yes.
Okay. You don't know where any communique was sent or received, correct?
No. No, sir.
You don't know who received it, correct?
Who received the messages that I sent?
Correct.
No, I do not.
Okay. You don't know where it was received, do you?
No, I do not. I sent it to the number I had for Michael.
Right. You don't know whether any device was hacked, correct?
No, I do not.
You don't know whether somebody within the residence may have been using the same router.
No, I do not.
Correct. Thank you.
All right, thank you. State.
Nothing further, Judge.
All right, thank you for appearing today. You're released from further testimony. Have a good day.
Thank you.
I have a question. So if somebody in the residence was using the same router that Laurie Shaver uses, doesn't it make the most sense that it was Laurie Shaver using that router in the same residence that she always used for everything else? I am so confused as to what the strategy is here.
Thank you.
Yes, ma'am.
The state calls Scott Amatuccio.
All right, good morning. Please come up to the witness stand. Please be seated and make yourself comfortable. Let me know when you're ready to proceed. And please state and spell your full legal name.
Scott Amatuccio, SCOTTAMATUCCIO.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Please proceed.
Did you know Michael Shaver?
Yes.
How did you know Michael?
We were best friends.
And when did you first meet Michael?
It's about second grade.
And where were you all living at this time?
In a small town, Lawrence, New York.
And what about Laurie Shaver? When did you first meet her?
We had all known each other since about kindergarten. We all went to the same K through 12 school. I didn't really start to hang out with her until they started to date.
When did Michael and Laurie first start dating?
It was about 8th grade.
And specifically, were you present when they first got together?
Yes, he asked her out in my bedroom.
Okay. And did he make any special requests to you at that time?
Yeah, he had me play Boys to Men in the background.
Now, did you maintain a relationship with them after everyone graduated high school?
I did.
And did you stay in New York after high school?
Yes, there was periods of time where I moved to Florida, moved back to New York, moved back to Florida.
Okay. What about Michael and Laurie? Did they maintain their relationship after high school?
Yes.
And did you maintain your friendship with both of them?
Yes.
And did they stay in New York? What did they do?
We all tended to kind of follow each other around. It's just how it worked out. So, I would live in New York and they happened to be in New York. I moved to Florida. Eventually they would move to Florida. It just happened to work out that way. Eventually we all settled down in Florida.
And when they were living in Claremont, Florida, where were you living?
Gainesville, Florida, for most of that time, and then I had moved to St. Petersburg, Florida, toward the end.
Now, at some point...
Gainesville, I believe, is probably about an hour and a half from north of Claremont, and St. Petersburg is probably an hour and a half, probably about an hour west of Claremont.
Did you start dating a woman by the name of Katina Vasquez?
I did.
And when did that relationship start?
That started about 2000 and it's been so long, 2006, 2007, that time frame.
Where did that relationship begin?
New York.
And at some point, were you and Katina engaged?
Yes.
And did she come with you and move down to Florida in one of these time frames where you were living down here and Michael and Laurie were living down here?
Yes.
And when they came down, did Katina and Laurie become friends with each other?
They did. They became close friends.
Now, I want to move to March of 2015. Were you still dating Katina at that time?
March 2015, no.
Was there, after you and Katina ended your relationship, did she maintain a friendship with Laurie Shaver?
She did.
Now, going back to that March of 2015, was there a time frame that Michael Shaver came to visit you at your home after the breakup with Katina?
Yes, if I recall, that was November of 2014.
Okay. I apologize about mix up on the dates. What was the status of the relationship between Mike and Laurie at that time?
He didn't really talk too much about how their relationship was. I could tell there was some tension and they were on and off. I don't believe they were dating at that time.
Object. That's speculation as to the emotional feelings and mental processes of another individual.
Sustained.
Did you see him in July of that year?
I did, July 2015.
Where was that?
At his house.
And was this the last time you ever saw him in person?
It is.
After November of 2015, did you speak to him by phone or have any other personal communication with him?
No.
Did you attempt to reach out to him between November of 2015 and 2018?
A few texts, and that's it.
Did he ever respond to any of your texts or attempts? Now, in 2018, did you have a conversation with Katina that she had about a visit to the Shaver residence in November of 2015?
Yeah, that conversation was actually that was toward the end of 2017, maybe early 2018. It was right after my then relationship had ended. That's how I can pinpoint that.
And did the information that you got give you further concern about Michael Shaver and his safety?
Absolutely.
Once you got that information, what did you do?
I first messaged, excuse me, I messaged Mike's sister on Facebook, told her what I had found out. I told her I'm going to file a missing person report based on that information. It was disturbing. I then called the sheriff's office.
And had you talked with Michael Shaver's family about their inability to get in contact with Mr. Shaver during this period as well?
I did.
I have no further questions.
Mr. Wiggs?
Yes. Do you know about any injunctions that have been imposed against Michael Shaver?
I knew of one.
Okay. When was that?
2014, 2015, somewhere around that. I don't know the specific details of that.
A direct examination, we heard you recall dates pretty quickly, correct? Pretty specifically, correct?
Yes.
You remember an injunction, but you think it may be 14, maybe 15, correct?
Correct.
But you know there was an injunction, correct? All right. So Michael was not in the house for a certain period of time, you were aware.
He has personal knowledge of when his conversations with Michael occurred. He has no personal knowledge of when the police would have issued an injunction against Michael or any other court case involving Michael and Laurie. He would have heard that secondhand, which means he wouldn't remember the date that any injunction issued. He wouldn't necessarily remember. He's just badgering these witnesses. I really don't think the jury is going to like this guy. We don't like this guy, and we're not even sitting there in the room with him.
Aware of, correct?
Correct.
Okay. Do you know where any messages came from?
I know there were, I had never received any messages from Mike.
Okay. When was the last date you received a message, and do you know where it came from?
It would have been that around that time that was I had last seen him at his house, and I had never heard from him after that.
Okay. Did you witness a homicide in this case?
No.
Do you know where Mike was the last 24 hours of his life?
No.
Do you know what Mike was doing the last 24 hours of his life?
No.
Do you know any altercation, anybody that was involved with Mike?
No.
Thank you.
State?
Nothing further, Judge.
And may the witness be released from a subpoena?
Yes, sir.
All right. Thank you for appearing today. You're released from further testimony. Have a good day.
8 calls Corey Anderson.
You knew way too much information. It can show you.
Bring it out 13.
Again, the judge had to turn off the microphones in the courtroom because we could hear what the defense attorney was talking to his client about. They're not even trying to whisper at this point.
Only swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Please proceed.
Please introduce yourself to the jury.
My name is Corey Anderson, and I'm employed with the Lake County Sheriff's Office.
And how long have you worked with the sheriff's office?
Since 2005, so it's about 19 years.
What is your current division or assignment?
Right now I'm a corporal. It's a first line supervisor in the Special Investigations Bureau.
And back in 2018, what was your position?
I was a corporal on road patrol, where I supervised the shift in the south end of the Lake County.
And as a corporal over road patrol, what were your duties?
So supervising this 5 to 7 deputies on your shift, approving the reports, responding to in progress or important calls that desire a supervisor's presence to be there.
Before we get into your involvement in this case, let me ask you, what is a well-being check?
So a well-being check is anybody can call the sheriff's office if they haven't spoke to a loved one or a friend or a neighbor. They can have the sheriff's office go out and acquire to ascertain the safety of the person that they're trying to get a hold of.
And in February of 2018, were you tasked with performing a well-being check on Michael Shaver?
Yes, sir.
And as a part of that, where did you go?
So I went to the Sandy Pines Road in Claremont.
Was that in Lake County?
That is in Lake County, yes, sir.
And was that the last known residence of Michael Shaver?
Correct.
And who all was there that you made contact with at that time?
So myself and Deputy Kyle Morrison.
Okay. Mm-hmm. Who did you make contact with at the Shaver residence?
Oh, I'm sorry. I made contact with Miss Laurie Shaver.
And do you see her and recognize her in court today?
Yes, sir, I do.
And then can you please point her out and identify her by something that she's wearing?
She's wearing a tan jacket.
And when you got there, did you tell her why you were there?
I did.
And did you ask about the whereabouts of Michael Shaver?
I did, sir.
And what did she tell? Where did she tell you Michael?
She said that she hasn't seen him since, I think, October of 2014, and that he kind of just absconded the family.
Okay. And did she mention to you if she had any phone or text contact with him since then?
She did mention that he had not reached out to the children or her in some time.
Did you ask her if it was okay to look in the backyard?
Yes, sir, I did.
And why were you interested in the backyard?
Part of the information that we received on the well-being check was that there was a new cement slab.
Is your second? John, can we approach?
Come on up for sidebar. Thank you.
It sounded like the objection was hearsay. So he is testifying as to what the nature of the wellness check was, but he should be able to testify as to why they wanted to check the backyard. He's not offering that the information that the person who asked for the wellness check to give, he's not offering that for the truth of the matter asserted, which is what would cause an objection to hearsay. If he's offering it for the truth of the matter asserted, then it's hearsay. But he's not offering it for the truth. He's offering it to show why he wanted access to the backyard and why he wanted to see this fire pit. So it shouldn't be subject to an objection.
Did you go into the backyard?
Yes, sir, I did. I observed a cement slab in the backyard where there was, it looked to be like brick rock structure that created the fire pit.
Now, in the course of your law enforcement career, have you responded to scenes that involved bodies buried in shallow graves?
Yes, sir, I have.
And approximately how many times have you went out and made those types of observations?
I've been on those scenes, probably between 5 and 10 scenes similar to that. Yes, sir.
And was there anything that you saw about the cement slab itself that gave you some concerns?
Yes, sir.
And what was that?
So as I approached the cement slab, you could clearly see a depression that was approximately between 6 feet and 3 feet in dimension and about 8 inches depressed. It had the shape of what could be a normal-sized adult body.
Did you take photographs of that cement slab at that time?
Yes, sir, I did.
How did you do that?
With my cell phone.
Showing defense what has been previously been marked as State Exhibit Z.
Yes, sir.
I'm showing witness what has previously been marked as State's Exhibit Z. Do you recognize those photographs?
Yes, sir. I took these photographs with my phone.
And is that a fair and accurate depiction of the cement slab as you saw it the day that you were out there with Ms. Shaver?
Yes, sir.
All right, this time the state moves State's Z into evidence as State's number 15.
Objection.
Without objection, State C will be moved into evidence as State's number 15.
I'm sorry, I skipped. It should be 14.
14, okay, State's number 4. Z will be admitted into evidence as State's number 14.
Your request permission to publish?
Granted.
Now, Corporal Anderson, is this the first photograph that's in State's number 14? You have to answer out loud.
Yes, sir. It is.
Okay.
Yes.
Now, can you step down and just demonstrate to the jury the area that gave you pause and concern when you were out there?
Down here?
Yes.
Okay.
And be careful, if you touch that screen, it's a touch screen, it may advance on you.
Sure, I understand. So, obviously, I took this picture, so I'm really standing right here looking at the cement slab. I believe Ms. Shaver was on my left, and Deputy Morrison was across from me. As I approached, with permission to be on the property, I just snapped a few shots with my cell phone so that I could really portray what I'm actually seeing to supervisors, to the Criminal Investigation Bureau for further investigation.
I'll advance to the second photograph. Is this the other photograph that you took?
Correct, yes, sir.
Now, can you show the jury the area of that depression that you previously described?
So this darkening area is the depression. So it was about 6 feet in length and about 3 feet in width. And it appears to be like a makeshift cement slab where it wouldn't be as thick and could have a depression if there was a shallow grave there.
And when we're talking about a depression, are you saying that it was not flat across?
Correct. So you could actually see where that darkening area is, where it was depressed and water would settle there, which is brought the dirt that stays in that area.
And just to make sure everyone's clear, can you just point to the area on that slide that shows this depression?
This is the depression area.
Thank you.
Darkening area.
Now, after these observations were made by you, did the sheriff's office obtain a search warrant to further search that area and the backyard of the Shaver residence?
Yes, sir.
And were you involved in the actual excavation of that area?
I was not actually involved in the excavation, but I was on scene for scene security. So basically keeping the media away from the Shaver residence just so that we could maintain our
between the time frame that the scene, when you made those observations, did the sheriff's office maintain security with this scene until it was searched?
Yes, sir, they did.
And when we talk about maintaining that scene or securing it, what does that entail?
So it was 24-hour security where a deputy sheriff sat out in front of the property. And
So remember when we read the probable cause affidavit yesterday? In the probable cause affidavit, we learned that Ms. Shaver had allowed them to come on to the property for this wellness check. And then at some point when they went into the backyard and then wanted to have the cadaver dogs and they asked for permission to bring out the cadaver dog, Laurie Shaver objected to that and said, no, you all have to leave. So he did slip in there. I took this photo and quote, with permission to be on the property. So he's gotten the jury to realize, to at least hear, that he had permission to be on the property. Now, he can't say, and then the defendant exercised her constitutional rights, right? He can't come out and say that. Hopefully the jury read between the lines, and even though he didn't say she didn't exercise her constitutional right to kick us off the property, hopefully they heard that that's what she did next. And so that's why we had to go get a warrant to complete the search of her property.
it was 12-hour shifts. So
We had 24-hour coverage on that property until we secured that search warrant.
And during that time frame, were able to maintain visual sight on this area. This meant not you personally, but they would be in position to observe it and maintain and make sure the property had not been changed.
Correct. Yes, sir.
Nothing further, Judge.
All right, Mr. Wiggs?
Yes, thank you, Judge. Corporal, correct?
Yes, sir.
Okay. Now, do you know what this ground looked like prior to this concrete being laid?
I don't, sir.
Okay. Do you know if this would have been dug out and it created a natural inclination for the concrete to be placed there?
I do remember Mrs. Shaver stating that prior to Mr. Shaver leaving, they were going to create some type of duck pond, but they didn't.
You have a little more experience in law enforcement investigations than a lot of people, correct?
Some.
Okay. Some?
Some.
Okay. You made it to the status of a corporal, correct?
Yes, sir.
Okay. And this dark spot led you to believe there may be a body under there, correct?
A shallow grave for sure, but not necessarily a body.
Okay. We see a dark spot over there, correct?
I do, yes, sir.
Was there a body over there?
Not in that specific area, no, sir.
Okay. We see shading back in here. Was there any evidence of a crime there?
I didn't see any, no, sir.
Okay. We see shadow areas throughout this, around these posts and stuff. Was there any evidence of a crime or a vomit or a body under any of those locations?
No, sir.
Okay.
So he's now pointing out all of the areas under this slab that there was no body, right? The only reason that that would matter is if you are trying to fight the validity of the search warrant that was obtained, that was then executed, and they came back and found the body under the slab. That's the only reason that would be relevant. It doesn't matter in this case to the jury, to anyone, where the body wasn't. All that matters is that there was a body, and it was right there under that spot that I had indicated looked like there may be something decomposing under that spot. That's the only thing that matters. None of this matters.
Now, when y'all were out there doing the excavating, Miss Shaver remained there at the residence, correct?
For most of the time, when she was free to leave.
Yeah. Did she leave?
She did.
She did? Did she try to take flight in any manner, not return to the property?
No, sir.
Okay. One moment, please.
Yes, sir.
He's getting dangerously close to asking, did she invoke her right?
All right, and may the witness be released from a subpoena.
Yes, sir.
Thank you for appearing today. You're released from further testimony. Have a good day.
Good
Yes,
thing
sir.
he stopped asking questions.
Can we approach?
Yes, sir. Come on up.
Let's see what they're doing.
The jury, Attorney Camuccio is setting up a disc containing the perpetuated testimony of witness Jessica Holcomb. That video, that disc will not be in evidence. You will not be able to bring the disc and rewatch the video, so please pay special attention to the video, as you will not be able to watch it again. The testimony is the same as any other witness. So if you wish, please take notes.
There's a few reasons why you would perpetuate testimony. One is perpetuate testimony because there's a likelihood that the potential witness is going to pass away. You can also perpetuate testimony because the witness exists outside of the state's jurisdiction and cannot be compelled via subpoena to come into court, because we don't have that. Florida attorneys don't have the right to say go into Montana and subpoena somebody. They would have to get permission from a Montana judge, and there's a whole process for that. And to avoid all those complications, they will typically perpetuate testimony. And our subpoenas don't even work outside of, I believe it's 100-mile radius, something like that. So they basically depose the witness. Instead of it being an evidentiary deposition, it is a trial deposition, and both sides know that it's a trial deposition. So any objections have to be raised during the deposition, and those objections are then heard in court after they raise them during the actual questioning of the witness.
Okay, just God, make yourself comfortable.
Sounds like the audio quality is going to be bad here.
For purposes of perpetuation, you're out of state. Call Jessica Holden.
Okay, Jessica Holden. Please come up to the witness stand. Please make yourself comfortable and let me know when you're ready to go. All right, please state your name for the record and raise your right hand.
And it's Jessica Beard Holcomb.
And you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God.
I do.
All right, thank you. Please proceed.
Thank you, Your Honor.
Yes, sir.
Ms. Holcomb, what do you do for a living now?
I am a crime scene investigator and evidence technician at the Tiberias Police Department.
What do you do there on a day-to-day basis?
Mainly, I deal with the evidence sections, and then I am also on call for any crime scene.
How long have you worked in Tiberias PD?
Approximately a little over a year now.
Where did you work before that?
At the Lake County Sheriff's Office.
What did you do for the Lake County Sheriff's Office?
I was a crime scene investigator.
How long did you do that job for Lake County?
I was there approximately 12 years.
What did you have the same general duties and responsibilities at Lake County as you do now with Tiberias Police Department?
At Lake County, my main focus was crime scene.
Can you describe your training and experience that allows you to do the job of a crime scene investigator?
I have a bachelor's degree in criminal justice, and I have a master's degree in criminal justice with a focus on forensics studies. On-the-job training for all the years I've been in this field. Just basically hands-on, multiple scenes. I think I've been to over 600 crime scenes throughout my career.
During the course of your training and experience in the seminars you've gone to, are you trained how to collect different types of evidence?
Yes.
Right. Please direct your attention to March 9th and March 10th of 2018. Did you assist in the excavation of some human remains located at 9850 Sandy Pines Road, Claremont?
Yes.
Was crime scene investigator Jessica Wade also present and involved in the excavation process?
Yes.
I plan on asking Jessica Wade more detailed questions about the step-by-step excavation process and what was found. So I'm going to ask you some general questions about some evidence you actually collected, okay?
Okay.
During the excavation process, were human remains eventually discovered?
Yes.
Briefly, can you describe how you came about to locate those human remains?
At the end of the first day, we came across a humerus bone. It was underneath a fire pit. The fire pit had been broken up in order for us to be able to locate that first initial bone. The light was receding for that day, so we closed down the site, secured it, picked up the excavation the following morning, started digging again, and then came upon a blue tarp.
Yes. You mentioned blue tarp?
Yes.
Showing you what's marked in states as a date for identification. You take a look at this item, look at it, recognize it. First of all, is that item sealed?
Yes.
And what do you mean by sealed?
It is in a brown paper bag sealed with evidence tape, and it has my handwriting on it describing what's inside.
Can you describe the process you go through when you actually find a piece of evidence, collect it, and place it in the bag and seal it?
So when we find anything of evidentiary value, we denote it. Basically, we photograph, video, anything to document it on scene. We put gloves on, we collect it in a manner that's deemed appropriate, and then we'll get the appropriate collection packaging, in this case a large brown bag, and then put it in the packaging, and then we'll seal it.
So this large brown bag that I just handed you, can you open it up, look inside, and tell me if you recognize the contents?
Yes.
Some gloves next to you.
Remember how long it took to open that bag in the Telus trial? That's what we're waiting for.
We ended up separating different quadrants. We were processing it at a later date. This is labeled quadrant E. This one. Yes, this is going to be the same blue part that was located.
Except for the additional processing that you have just described, does it appear to be in the same or substantially the same condition as when you collected it during the excavation process?
Yes.
This time you're going to state with states A and the evidence is states 1.
States A will be moved into evidence, states number 1 without objection.
You mentioned that item was taken back to the lab at a later time and processed further.
Yes.
What exactly? You said it was cut into quadrants?
Yes.
Explain what that process was.
Well, it's a relatively larger tarp, so we didn't lay it all out, document it. We did cut it into smaller quadrants in order to process it further. We looked at it from ALS, an alternate light source, and then we also processed it for latent fingerprints. We did find hair-like fibers on a couple of different quadrants that we collected, and then there was a defect that we found in one particular area that was of interest that we did cut away and collect as well from the tarp.
Speaking of that defect in the area cut away, may I approach you, Your Honor?
Yes, sir.
Showing us the marked stakes as B as in boy. Take a look at that item and tell me if you recognize it. Is it also sealed?
Yes, it is. With my handwriting on the envelope. Yes, that appears to be the piece that we cut away from the tarp.
Is it the same, substantially the same condition as when you processed it and cut it away?
Yes.
This time, State will move B into evidence as States 2.
Any objection?
No objection.
Without objection, States B will be moved into evidence as States number 2.
Now, during the excavation process, once you removed that blue tarp that you just looked at, what was found underneath?
So the human remains were found underneath. At the very beginning, we saw the skull. There was a green strap wrench around the remains as well, and there was also appeared to be like a piece of fabric, like a tag with an elastic band, almost like a fitted sheet. The elastic from a fitted sheet left on the remains as well.
Was a Tupperware used in this excavation process around this period of time when you're uncovering the remains?
Yes, there was Tupperware used to collect the smaller bones during the excavation process, and then as well for all the debris and the remnants that were collected near the remains.
Once you put those remnants that you just described into that Tupperware, did you collect that Tupperware, that green nylon strap, as well as that piece of elastic?
Yes.
May I approach you, Andrew?
Yes, sir.
Showing the marked States 2. E. Is this item also sealed?
Yes.
You can open it up, take a look, and tell me if you recognize the contents. What's inside?
Yes. Tupperware and a nylon.
Are the items the same, substantially the same condition as when you collected them during the excavation process?
Yes.
This time, State will move E into evidence in States 3.
Any objection? No objection. Without objection, States E will be moved into evidence as States number 3.
Did you also locate some clothing during the process?
We did.
Can you describe what kind of clothing you have?
So on the remains there were two socks, some boxers, and brown or black shorts.
And did you collect those clothing items as well?
Yes.
Can you explain how you collected those items?
So when the remains were removed from the ground, the medical examiner, the forensic investigator, and Dr. Sutton, they were basically in control of the remains. They were basically had sheets laid out where they were identifying certain bones and trying to lay out what pieces were there. So during that process, they were taking the bones and kind of sorting them out, and then they were taking the clothing, and we had the bags and whatnot for collection waiting. So they would just drop the clothing in the bags, and then we would take the bags and seal them.
Showing us Marcus States Exhibit D as in dog. You mentioned he collected some boxers and some shorts.
Yes.
Can you take a look at that item and tell me if you recognize it?
The boxers and the Under Armour black shorts.
Are those items in the same or substantially the same condition as when you collected them?
Yes.
Yes, okay, I'm sorry. At this time, around the state will move states Exhibit D as in dog, and then this is State 4.
Any objection?
No objection.
Without objection, states Exhibit D will be moved into evidence as states number 4. Thank you.
You also mentioned some socks were collected, showing you states Exhibit C. Can you take a look at that and tell me if you recognize it? Are they in the same condition when you collected them?
Yes.
This time, state will move C into evidence in states 5.
Without objection, state C will be admitted into evidence as states number 5.
You mentioned earlier there was a fire pit.
Yes.
How far was that fire pit away from the location where the human remains were found?
The remains were found almost directly under the fire pit.
Was the fire pit broken up during the excavation process?
Yes.
Did you examine that fire pit?
Yes.
Did you locate anything, a piece of flooring in that fire pit?
Yes.
Describe that.
It's a piece of what appeared to be laminate flooring, like a wooden parquet design.
Did you collect that piece of evidence?
Yes.
Showing was the marked as State's Exhibit F is in frame. Do you recognize that item?
This is my handwriting on the top of the bag.
Like the other items, is that also sealed?
It is. Yes, this is what was collected on scene. Yes.
Is it the same substantially the same conditions when you collected it?
Yes.
This time state will move F as in Frank into evidence of state 6.
Any objection? States F will be moved into evidence as states number 6. Without objection.
retention until later on in the afternoon on March 10th of 2018. Did you make contact with a man named Douglas Shaver?
Yes, I did.
Where?
Out front on the street in front of the residence.
In front of the same property and residence that you have been excavating?
Yes.
And how did that come about? How did it come that you had contact with Mr. Shaver?
I was informed by one of the detectives that he was out front.
And who was Douglas Shaver in relation to Michael Shaver?
His father.
All right. Did you take a photograph of Mr. Shaver when you made contact with him?
I did.
Showing those marked Stacy's Exhibit H for identification. You recognize the person in that photograph?
Yes, that's Douglas Shaver. Yes, I took that photograph.
This is fairly inaccurately depict what Doug Shaver looked like at the time.
Yes.
This time statement moved H into evidence as States 7, I believe.
Yes, sir, States 7. Any objection?
No objection.
Without objection, States H will be admitted into evidence as States number 7.
Did you collect any evidence from Mr. Douglas Shaver?
Yes.
What did you collect?
I did fecal swabs.
And what is a buccal swab?
So those swabs are taken for identification purposes. It's basically a swabs taken from the interior lining of the cheek.
And how do you go about doing it? What do you use to take the swab?
Basically just 2 swabs, gloves on, take the swabs, rotate the swab around the inner lining of the cheek, put them in a swab box, and then I seal it in an envelope.
Is the swab kind of like a Q-tip?
Yes.
Was Mr. Douglas Shaver cooperative with that procedure?
Yes.
And once you collected those swabs from Mr. Douglas Shaver's cheeks, what did you do with the actual swabs?
I put them in an envelope, sealed them, and locked them in my vehicle for just collection purposes, and then took them back to the lab.
Approach me, Your Honor?
Yes, sir.
Showing you State's Exhibit G for identification. Do you recognize that item?
Yes.
How do you recognize it?
It has my handwriting on the envelope, and it's sealed.
Look inside, tell me to recognize the contents.
Yes, this is the swab box that I wrote out with the swabs inside.
And are those in the same or substantially the same condition as when you collected them from Mr. Douglas?
Yes.
Time statement moved G into evidence as State's 8.
Any objection? Without objection, States G will be moved into evidence as States number 8.
Were those swabs that you collected from Mr. Douglas Shaver sent to the Florida Department of Law Enforcement for future analysis?
Yes.
Did you have any involvement in that actual analysis done at Florida Department of Law Enforcement?
No.
Did everything you testified to today occur in Lake County?
Yes.
Thank you, ma'am. No other questions, Your Honor.
All right, Mr. Wiggs?
Yes,
Yes, sir.
Officer, you go by deputy or officer, ma'am?
I'm not sworn, so investigator's fine.
Okay. Have you ever been a sworn law enforcement officer?
No, I haven't.
Okay. Because you investigate crimes.
I do.
Just let me ask one question, please. I don't want you to interrupt, if you would, please. Is there a reason you left the Lake County Sheriff's Office?
Yes, Your Honor, relevance.
All right, come on up for silent. All right, please proceed.
Going to Barry's Police Department, was that a promotion?
And sorts, yes.
Okay. Well, did you receive more pay over there?
Objection, relevance.
Sustained.
Okay. Ma'am, do you have anything that has affected your ability to perform your functions?
No.
Okay. Have any health reasons?
Objection, relevance.
Sustained.
When did you get involved in this case?
When I was given the call that I needed to respond.
Okay. Who called you?
I'd have to refer to my report, but I believe that we were told that there was a staging area the day before, and that we had to proceed to the staging area. So I knew that we had to report to the staging area, so we all showed up there. The search warrant was supposed to be given that day, and then we all were supposed to proceed to the property.
Okay. Let's talk about some of your testimony. You testified you found the blue tarp, correct?
Correct.
Okay. And do you know where that blue tarp came from?
The ground.
Okay. Do you know who manufactured that blue tarp?
No.
Okay. Did you do anything to see who had? Not a true question. Did you do anything in your investigation to see who manufactured that tarp?
I don't believe there was a tag on it, or if there was, it wasn't legible. No.
Okay. So I think that would be a no, correct?
That's what I just said, sir. No.
Okay. Now, did you find on that tarp any DNA associated with Laurie Shaver?
I personally didn't know.
Okay. Do you know if anybody did?
No.
Okay. Did you find any, or do you know if anybody found any blood on that tarp associated with Laurie Shaver?
I don't believe so.
Okay. Do you know, you spoke about some hairs that were found
Yes.
within your investigation. Do you know if anybody was able to link up any hair within that investigation, within the evidence that you collected that could be linked to Laurie Shaver?
I collected it. I don't know what the results were.
Okay. There was a strap you testified about, correct? Could you describe the strap?
It was a green nylon strap and a strap wrench that one can kind of wedge back and forth to tighten.
Okay, a strap wrench, correct. Is this used to tighten straps that you may use on a vehicle or a boat?
A tie down, something like that, yes.
Okay. Did you see a vehicle that in any manner you could link it had come out of?
You could use it for any type of vehicles or any application, but they're very common.
Okay. In your investigation, whatever you did, other than what you've testified to, were you able to link that strap to the residence of Laurie Shaver?
My job would be to collect it, so you have to ask one of the detectives.
Okay. Do you have any personal knowledge whether or not that wrench or any of the straps could be connected to the residence of Laurie Shaver?
No.
There was some flooring you spoke about.
Yes.
Okay. Would you describe the flooring?
Like I said earlier, it was a piece of wooden flooring, parquet design.
Okay. Could that be linked to Laurie Shaver to your personal knowledge?
I was informed that there had been remodeling done. Therefore, I collected it on scene.
And who did the remodeling?
I was informed that Laurie did the remodeling.
Okay. Do you know if anybody else did any remodeling on that scene?
No.
Okay. And you showed us you moved through you and evidence a photo of Doug Shaver.
Yeah.
Correct? You know where Mr. Shaver resides?
It was in another state.
Okay. And you were at the scene that Mr. Shaver, he didn't just surreptitiously show up, correct?
Correct.
Okay. Somebody from law enforcement had contacted Mr. Shaver, correct?
Correct.
Was Mr. Shaver advised that y'all wanted your office wanted DNA from him?
I was just informed he was outside and I needed to collect DNA from him, so.
And who told you that, or advised you
One
that?
of the detectives on scene.
Who was that?
I can't recall the exact detective because there was a lot going on that day.
Okay. Now you testified that Mr. Shaver was found in the middle of the concrete fire pit, correct?
Well, underneath it.
Well, you testified on direct examination he was in the middle of the concrete pad. Did you not?
Well, I said underneath it.
Okay. So you don't recall saying he was in the middle of it?
I didn't say the exact middle of it. I said.
Okay. So let's specifically, through your testimony, you tell me where he was. underneath that pad to some degree of certainty?
So the fire pit had to be removed in order for us to access the remains. That's what I said, sir.
Okay. Now, where was he underneath the fire pit? Do you have any degree of specificity you could lend the court?
So the fire pit was not a complete circle. It was a very irregular shape, pretty much the shape of Africa. There was a point jutting down towards the residence. I want to say off to the left earlobe towards the point would have been probably the location we found him.
Okay.
There were initials on the fire pit.
Excuse me, I didn't mean to interrupt you. Near the edge of the pit?
There were initials on the fire pit, and they were probably pretty close underneath where the initials were.
Okay. Which portion was he near the edge of the pit?
To the left-hand lobe, if you're at the residence looking out towards the field.
So she described the fire pit, the shape of this concrete, as kind of looking like Africa. And I actually noticed that when I looked at the picture as well. And when she's talking about the lobe, if you've ever heard people talk about the difference between Indian elephants and African elephants are one of the differences is the shape of their ears, and their ears. The ears of an African elephant are kind of shaped like the continent of Africa. And so when she talks about this left earlobe, she's probably talking about if you were thinking of an ear of an elephant, and in which case the elephant would kind of been the ear would have been this ear, and the lobe would have been down here somewhere on the continent of Africa. And she's saying the body was found toward the lobe area of the African elephant, which is what this shape kind of looked like. And that is consistent with what the prior witness said regarding where the body was located, which was under that bottom portion of the concrete structure, and is also consistent with the reports that the body was located underneath the initials.
Now, you recovered some socks from the pit, correct?
Correct.
Okay. Did you recover any items that were women items, such as women's lingerie or anything of that nature?
No, the clothing that was recovered was on the remains. So.
Okay. I'm not asking you what was on the remains. I'm asking you, did you recover any items that Let me ask my question, please. Did you find any items that were linked, that constituted women clothing?
No.
Okay. Did you locate any items wherein somebody may have wiped their hands that contained blood or any substance from another person's body?
Anything that was on or around or near the remains we collected.
That's not my question. Did you recover any items independent of the socks, the blue tarp, the boxers, the strap, the flooring, that constituted independent items that somebody may have used to bury the body, where they may have wiped their hands or their own body with it?
Those are all items I collected.
Did you collect something independent of what you testified to?
No.
Okay. Then you would agree there was no items of Laurie Shaver that were linked to this crime?
If the body had been in there for 2 years, I have no idea what could have degraded or decomposed at that point.
So you know the body's been there for 2 years?
Per the medical examiner, that was what they had told us.
That's what they told you. Who told you that?
I just said the medical examiner.
Okay.
We know when the concrete was poured. We even see it on Google Images from 2016 that the concrete was there in 2016. So we know it. We know that the body was underneath the concrete for at least 2 years. We also know that the initials would have been etched into the concrete by Laurie and her then lover, who helped her pour the concrete. So, yeah, we do know the body was there for 2 years.
His name?
The medical examiner, I'd have to refer to my notes, but the one that examined the body and actually did examine the bones.
Okay. You would agree, ma'am, on direct examination, you had your answers, correct?
Yes.
But now you're saying you'd have to refer to some notes, correct?
To find out what the exact medical examiner was in 2018, yes, I would.
Yeah, but you don't have any independent recollection of that.
To find out who exactly that medical examiner was in 2018 for this particular case, I would have to refer my notes, yes.
But you recall that this medical examiner had advised you that that body had been in the ground for 2 years?
Yes.
Okay. And out of the evidence that you recovered, we know from your testimony and what you've done in this case, there was no DNA associated with Laurie Shaver on any of that evidence, correct?
I don't believe so.
Okay. There was no prints on any of that evidence associated with Laurie Shaver, correct?
I don't believe so.
And the character...
Were there any prints associated with anyone on that evidence? Did they collect any prints? Did she testify that they collected any prints at all? She said that they looked for prints. Did she testify that they collected prints? And if not, does that mean that nobody killed Michael and buried him in the backyard?
The evidence, none of it linked to any items within the household, correct?
You'd have to ask the detectives about that.
Okay, you don't have any independent recollection of that, do you?
Well, my job is to document and collect evidence on scene. I'm not there to investigate and go further.
Okay, but you spoke to the medical examiner. You remember that testimony, right?
Well, a lot of times I am there at the autopsy or I do hear things, yes.
Okay. One moment, please, Judge.
Yes, sir.
Aside from the collection of the evidence that you just spoke about, did you do anything else on this case?
No.
That's all I have. Thank you, Judge.
All right, thank you, Mr. Wicks. Mr. Buxton?
No question, Your Honor. Thank you.
All right, thank you. And witness step down for the witness. Release from her subpoena?
Yes, Your Honor.
All right, thank you for appearing today and release for further testimony. Have a good day.
Thank you, sir.
That was something. I don't know when this testimony was perpetuated, but
Disc about perpetuation as a court exhibit, not as evidence.
Yes, sir. So
he's been bad at cross-examination at least that long since this testimony was perpetuated.
it will be submitted as a court exhibit. Thank you. All right, at this time it is about 10 minutes after noon, and this will be a good time to take our lunch break. So please return by 1:30. Please return to the jury assembly room. Please do not discuss the case with each other or anyone else for that matter. Again, should you...
All right, so it looks like they are still at lunch. They went to lunch at 12:12. They are still there, it appears, because this is now live. And they are on lunch until 1:30, so they should be returning from lunch any moment now. However, even though they are returning from lunch, I'm still a practicing attorney. I have some prior engagements. So I'll tell you what we're going to do. I am going to stop here. And when I get done with my prior engagements, I'm going to pick back up with the second half of day 2 at that time. So I hope that you all will come back and join me as usual. If you all have any questions or anything, let me know in the comments, and I'll try to get the answers to those questions while I'm taking care of the other things that I have to take care of in the interim. Any questions about this case or the testimony that you heard here today, and I'll try to answer those questions before we go back and pick up with part 2 of day 2 of this particular case. As always, I am Nathan Saunders, and this is The Legal Good. Hope to see you all back here this afternoon. Have a good one.